Thank you, Mr. Berger. Am I to assume that the opposition with regard to the issues of condonation remain alive?
Yes, it does. It does.
So they'd be required to address that also. Good.
Thank you, my lord. My lord, subject to your directions, Mr. Berger and I agreed that we will be an hour and a half, and they will be an hour and a half, and then 30 minutes in reply. I hope your lordship got the note in which we indicated that we no longer persist with any defense in the Section 31 application other than the merits.
Yes.
So I want to address your lordship on
Good.
that at all.
Very well, thank you for that.
My lord, I will deal first with the meaning of Section 33 of the Act and the meaning of the words gross irregularity they do first. And then after that, with the two components of which we say is a gross irregularity, namely the first one, that the damage in this case, the damages were not general but special, and then secondly, that the onus to show compensatory benefit and the quantum thereof rested on the defendant in the arbitrations, but sorry, on the plaintiff.
So you're inverting your argument from initially
No,
dealing
my
with...
lord, I'll do it the other way. I'll begin with the compensatory benefits.
Yes,
And
good.
then secondly, then Mr. Bishop will deal with the constitutional point and the failure to develop the common law, to consider the development of the common law, and I will then deal with the extension of the six-week period set in Section 33(2).
Good. On the constitutional point, was notice given in terms of Rule 16 capital A?
No, ma'am.
Why not?
My lord, we didn't contemplate that it's that kind of direct constitutional challenge to a statute that was primarily the purpose of Section 16 of Rule 16A, because it comes from a time where parties were challenging a statute without joining the minister, and in that setting, it was adopted to make sure that an interested party is alerted or joined.
Well, aren't the interested parties in terms of trade unions, employer organizations?
Yes, my lord, that may well be the case. That may well be the case, my lord. Mr. Bishop is, do your lordship want Mr. Bishop perhaps address you on this now?
Well, he can address me later on it,
Okay.
but it gives him time to consider his position.
Thank you, my lord. Lord, if I can then start with the meaning of gross irregularity. And your lordship, of course, would have read the decisions and the heads of argument, but if I can take you to our bundle of authorities at page 14. At page 14 of our bundle, and paragraph 55 of Telfordia, which we accept remains the leading judgment. That's paragraph 55 of Telfordia, and your lordship, in the second sentence, the third sentence, Arams JAD lays down the general principle, or reports it, that when parties select an arbitrator as to the judge of fact and law, the award is final and conclusive, irrespective of how erroneous, factually or legally, the decision was. And further, at paragraph 85 of that judgment, your lordship will find the statement that the arbitrator has got a right to be wrong, and we all know that statement. So we accept, of course, that this is the general principle, that when you select an arbitrator, the award is final and conclusive. But there are three qualifications, my lord, of Telcordia that's recorded in that judgment itself. And if I can take your lordship perhaps to the first qualification that you'll find at paragraph 69. Whereas Lordship Justice Harms J.A. deals with the first qualification of the general principle that is now recorded. Paragraph 69 is about errors of law. And I'm not going to read it all, but in the last sentence, your lordship would find that the statement there is that likewise an error of law may lead an arbitrator to exceed his powers or to misconceive the nature of the inquiry and his duties in connection therewith. So when an error of law results in the arbitrator misconceiving the nature of the inquiry, that then is a gross irregularity. The second exception your lordship will find at paragraph 73. And that paragraph refers to the Goldfields investment matter, where the arbitrator had to consider a wide appeal, but he treated it as an administrative review. And in the bottom half of paragraph 73, the SCA holds as follows: the magistrate refused to conduct a rehearing and limited the inquiry to a determination of the question whether the valuation had been manifestly untenable. This meant that the appellant did not have an appeal hearing to which he was entitled at all, because the magistrate had failed to consider the issue prescribed by the statute. The magistrate had asked himself the wrong question. That is, a question other than that which the Act directed him to ask. In that sense, the hearing was unfair. So the second exception then is when the arbitrator asked himself the wrong question. The third one your lordship will find in paragraph 74, where Harms J.A. refers to another line of cases which dealt with reviews of inferior courts, which were concerned with orders made where a jurisdictional fact was missing. Put differently, a condition for the exercise of a jurisdiction had not been satisfied. And they referred to Primage, which is a case where the magistrate ordered security to be provided by a resident, and he only had the power to order security against a non-resident. And Fisser versus Estate Collins, where the magistrate didn't have knowledge about the time within which the rescission application had to be brought, but granted it nevertheless. So, my lord, in Telcordia itself, there are these three exceptions. If I can take you to the case that we particularly rely upon, which is Palabora, which your lordship will find at our bundle, page 31. And if I can just say in Palabora what happened there was that the respondent in the appeal, an entity called Matlokwa, they won a private tender. Sorry, my lord, that's at page 31. That's the beginning of the case. But just the factual background. Matlokwa won a tender, a private tender from Palabora. But that tender is now not implemented. And Palabora goes to court to have a declaratory order made that no contract ever came into existence. Matlokwa disputes that and also bring a counter application for damages on the basis that there was a contract. Now, just at paragraph 12, your lordship will find what Palabora claimed. Palabora's defense is, after it was found that there was indeed a contract, is to say that you, Matlokwa, could never have implemented the contract. You didn't have the skills and the financial resources to implement this. And it's in this context that we would like to refer your lordship to paragraph 42 that your lordship will find at page 37.
In your heads, you don't quote the full content of paragraph 42. As I understand 42, what is that there were certain rulings made during the course of the arbitration.
Yes, quite well.
And those rulings were important
Yes.
with regard to the conduct of the proceedings.
Yes. No, quite, my lord. We don't for a moment say it's on all fours with
No.
ours.
So during the proceedings, rulings are made which are found to be patently incorrect.
Yes.
And the arbitrator acts in terms of those incorrect rulings. And I think strikes out. Is that right?
That's right, my lord.
So during the conduct of the proceedings, rulings are made, strike out, and that impacts on the actual procedure of the arbitration.
No, quite, my lord.
Good.
So
the error in law gives rise to, firstly, rulings which are then struck out. Rulings are made, and in which certain averments are struck out during the course of the proceedings. If I understand from the earlier case, is that where the error of law, it's not just the error of law that gives rise to the gross irregularity. It has to manifest itself in the proceedings.
yes, quite, my lord.
Good.
In a failure to then
Yes.
ask the right question or not hearing a party.
Or impact on the procedure of the hearing.
Yes. No, quite, my lord. What happened here is, and your lordship, with respect, is quite right. He struck out, and that's why I took your lordship to paragraph 12 at the beginning, because those are the allegations that were struck out. These allegations that Matlakwa couldn't perform anyway, and therefore couldn't prove his damages. And then, but we submit that the general principle laid down here in this context is the effect of the arbitrator's ruling. I'm reading from paragraph 32. The effect of the ruling, especially striking out, as your lordship is correctly pointed out, of paragraphs 7.3 and 7.4 of the plea, was to prevent an exploration of these issues by relieving Matlakwa of any obligations, however light evidentially, to prove that it would have performed the contract and had suffered loss as a result of being prevented from doing so.
Sorry if I understand that. It's in the context of the proceedings itself.
Yes.
So there could not have been an exploration of the issues during the arbitration.
Yes.
That's crucial,
Yes.
because the exploration would have to take place during the arbitration.
Yes. No, quite, no.
Yes.
It is, if I'm not going to spend a lot of time on the next case, the Stocks Engineering case, my lord. But what we're contending for is that a mistake, a legal mistake as to where the onus lies, often has that effect that an issue is not explored then. That's the submission we make during the arbitration.
Yes.
That issue is then not explored, not heard, and it's that why both in this case and in Stocks Engineering, one finds that the courts say that the error made, the law error, the error in law regarding onus, is one of those which can have this effect of there not being a hearing, a proper hearing, and issues not being explored.
Is that what they say in Palabora?
I just read to your lordship
No, that's as I understand, the error of law led in the further procedure of the arbitration, no exploration of the issues.
yes,
Okay. The question of onus.
yes, my lord, but yes, here in fact the striking out led to a failure to explore those issues.
Yes. It's not a question. Principle of onus simply leads to a gross irregularity.
Yes, but the submission we make, my lord, is that if one is relieved here from a burden evidentially, this is what the finding is, it will be all the more so if one applies the onus incorrectly. If one reverses the onus, it will also by necessity, we would submit, have the effect of relieving a party of a burden.
Mr. Diwali, it has to be grounded in the context of the proceedings.
No, we accept that, my lord.
Yes, so if you accept that, let's look at the proceedings in the arbitration before this court. Okay?
Yes. My lord, if I could just ask...
I don't want us to get there. We'll get there later, but
Yes.
if you agree that it has to be grounded in the actual context of what took place in the arbitration, then I think we're going to have a different discussion. But you can't simply say because there was an error with regard to the issue of owners, therefore the proceedings were grossly irregular.
No,
You're going
quite.
to have to assist the court on that.
Yes, no.
Because of your
no, if it's not relevant to the proceedings or the
It
arbitration.
has to be relevant. Owners
Yes,
is
no, of
always
course.
relevant.
Yeah. No, I think it's called the material error of law. It's a material
Yes,
with the...
yes, but it's always relevant. But
Yes.
the question is, how did it manifest itself in the context of this matter?
Yes. No, quite, my lord. We'll certainly get there. If I can then, your
Certainly.
lordship would have seen stocks. I'm not going to address your lordship at length on stocks. It is at our bundle, page 63. And just again, my lord, the background here is that the arbitrator, this is a private arbitration, starts at page 62. It's a private arbitration, but the arbitrator relieved the employee of the duty, of the burden, of the onus to show that there was a dismissal. And then went straight to the question as to whether the dismissal was unfair, where the burden was on the employer.
But as I understand, the point there being that there was a statutory injunction with regards to the procedure to be followed in the determination.
I think the parties agreed that there would be a further standard as well, that the award may not be irrational or the procedures may not be irrational.
Yes, but
yes.
to the extent it's relied upon, the statutory injunction sets out the proceedings. A dismissal has to be established. Where does the
Yes.
onus lie with regard to the establishment of the dismissal? And then the second part of the inquiry is, was it unfair?
Yes,
Or was it lawful?
yes, quite one.
So there's a statutory procedure.
Yes, I'm
And
with
it
you.
impacts directly on the procedure in the arbitration.
I'm with your lordship. I just want to refer you to page 68 of the bundle,
Yes.
and your lordship would have seen there that it talks, Zondo JP talks more generally there about the three irregularities that there were in the case. And again, the first one at page 20, paragraph 27, in the middle of the paragraph, was really whether the arbitrator considered the question of whether the dismissal had been proved. If he did consider it, he disregarded matter that was so vital to that issue that the inference is inescapable, that he had no proper appreciation of the legal implications arising out of that issue, with the result that it cannot, in my view, be said that there had been a fair trial of the issues because there was an error in that the first issue wasn't explored. That's all that we use this case for, my lord. Because of the approach followed and the first step wasn't done, there was no burden. It wasn't recognized that the burden lied with the employee to show that there was a dismissal. From then on forward,
But did the employer in fact establish that during the course of the proceedings?
that there was no dismissal,
Yes.
that it was voluntarily.
Yes.
My lord, as I understand the case, it didn't turn on that. The employer wanted to establish that, but that was not what the arbitrator considered. He just jumped to the second phase.
No. Did the employer establish that there was no dismissal? It's not clear from the case.
No, I don't think it is, my lord.
Crucially,
Yeah.
because we don't know, and the record will show, which was before the court, with regards to how the arbitrator dealt with that issue.
Yeah. Yes, I accept that one.
So factually, we don't know, in fact, what happened in that matter. So it really can't be of great assistance to us
Lord,
now.
we're contending for a situation where, broadly speaking, and I know I'll come back to the facts, but broadly speaking, an error of this kind, onus, strikeout, relieving a burden on a party can translate into a gross irregularity, because then one doesn't consider the matter properly and ask yourself the wrong question. Of course, it's a bit different with the second leg of the argument, which is a special and general damages. There we say...
But let's just stop there. You see, it can't really simply be that because you get the law on onus wrong, that then establishes a reviewable gross irregularity. The proceedings must manifest that.
Yes.
And we don't know in stocks what was manifested in terms of the actual facts. We know in the previous matter, Palabora, is that right? How it manifested itself. Incorrect rulings on law, striking out. Therefore, the evidence led took a different form. So as I said, we'll get back to exactly what took place in this arbitration later on.
Yeah.
And to the extent that the facts are not in dispute, at least A, and B, nothing is indicated by the applicants with regards to the procedures adopted by the arbitrator, the initial arbitrator, that led to an unfair hearing, procedurally.
Yes. No, my Lord, I will get there. And I will speed up slightly to get there as soon as possible, my Lord. I just want to start with it, moving on to the second leg of our argument. I just want to start with a more general submission here, my Lord. We must apologize in a sense because there's a statement in our heads at paragraph 28.5 that these awards of damages against employees are not made, or it was a broader statement. But my Lord, you would have seen from the analysis that we prepared, the cases that's referred to in LAWSA, and also our own research, that just produced one extra case, my Lord, the Massmart case. We looked at all those cases. In the end, it was 10 of them. And I'm not going to go through them one by one, but your Lordship would have seen them. Those are all the cases that I could find in South African law in which an employer has sued an employee for breach of contract and claimed damages. The sum total of 10. And they fall into various categories. There's a category of short notice. The employee doesn't give the 30-day notice, but gives 15 days or 10 days. Those claims, in our research, those claims have always failed because the employer didn't manage, in those cases, to prove a loss. The cases that have succeeded, my Lord, your Lordship will find 2 of them in that list. The one is Stoop versus Rand Water, and the second one is the Massmart case itself. And those 2 cases, my Lord, concerns allegations of fraud and corruption. In other words, a situation where the employee stole money or benefited from the breach of contract. And then the second category is where there is an enticement to other employees to leave the employment. That's the Massmart situation, intentionally entice others to leave. Now, my Lord, both of those are also delicts, And we've gone through those cases because the submission is that it is an unusual claim. And certainly it's never been held in our law that one, as an employer, is entitled to claim damages for unauthorized expenditure only, without there being personal benefit. And if I can take your lordship to the papers at page 137. The university's pleaded case has never been in the papers 137. That's part of the appeal tribunal's decision. And in 137, your lordship will find the appeal tribunal recording the pleaded breaches of contract of employment of which the US accused Mr. Roux. Well, in summary, you'll find there's 17.1. This is the use of the financial computer system. I'm not going to read it, but your lordship will find it goes on to 17.3 over the page, 17.4, and then ends in 17.7. I just want to make the broad submission. There's nothing in there that alleges fraud and corruption. And in fact, the appeal tribunal then records at page 141, summarizes at paragraph 22 by saying, against this background, the principal basis of the US's complaint against Mr. Roux was that he lacked the authority to access the unrestricted reserves of US and to make them available to those 4 cost centers. So we would submit, and we're just making the broad submission, is this kind of claim has never been recognized in our law at all. I'm not making more of it, just to say it's an unusual claim because it hasn't happened that somebody's been sued purely on the basis of unauthorized expenditure without that additional element of fraud and corruption.
And the element of dishonesty.
Yes.
You find dishonesty. He acted in good faith.
Yes.
And he attempted to hide these transfers on the computer system because there would be no tracking of it, even though we had a box of documents locked up in his safe.
Yes.
So he's not an angel doing all of this. The other side could see it fairly strongly. They said he acted surreptitiously.
Yes. No, quite, my lord. And further to that is we don't challenge any of the factual findings. So we say that in our founding affidavit, we can't. What we submit, my lord, is this, is that finding of dishonesty or operated secretly, that didn't do any work in the actual 2 aspects that we are talking about today, which is where the onus lies, number 1, and the issue of whether it's special or general damages. It didn't translate onto a finding that you were dishonest and therefore and your lordship, just to take it a bit further, in our predecessors' heads of argument to the appeal tribunal, they pertinently raised this, and your lordship would have seen it. If I may just take you there to page 251. Their heads of argument at paragraph 174, the arbitrator's finding of dishonesty and bad faith on the part of Mr. Roux is without justification, respect, and so on. Now this is only relevant to this for this reason. Your lordship wouldn't find, and please correct me if I'm wrong, but I could not find any reference to dishonesty or bad faith in the appeal tribunal's award. So our submission is this, it couldn't have been central to the issue of onus or the special damages debate.
Except, Mr. Duval, you've raised this in the context of the unusualness of this case, because for breach of contract, there's never been a damages claim for unauthorized conduct. And the debate we're having is in that context. We'll get back to the issues of onus and general damages, but you attempt to portray that, given that this is so unusual, there's no precedent, there's no case law, and the only point that I've raised with you is that the other side says, hold on, your client in fact acted surreptitiously, and in fact there's a finding of dishonesty and bad faith, and even though the heads of argument challenges it, it doesn't mean that's not part of the factual findings of the arbitrators.
Yes. Of the initial arbitrator.
Yes.
My lord. Yes.
Which is not in dispute, even at this stage.
No, it's not in dispute, my lord. What is?
So,
yes.
So the heads of argument doesn't help.
Yes.
I couldn't understand what the help of the lengthy heads of argument filed in review proceedings. It was just a burdensome exercise of me having to read the heads of argument which the appeal tribunal would have considered in detail. What does it say to me other than the point that you wanted to make? It would appear was that the issue was mainly about transfers as opposed to expenditure, but the appeal tribunal dealt with that.
Yes, well, we will move on from this then. I suppose the reason why we annexed the heads is that we provided the summary in the founding affidavit of the heads, and then it was annexed for that purpose.
It's not helpful. It's law.
Yes. Yes, ma'am.
I mean, it's heads of argument. You don't even, in fairness, put the other side's heads of argument and say this is what they argued. You know, it's not a helpful way of assisting a court on review, just to be given one set of heads of argument.
In mitigation, they do plead their heads.
Yeah, but they don't attach the heads to say that, yes, okay, read all of this. The simple point that they're having to respond to what you say. But you can't re-debate the issues, the factual issues before
no, we don't.
This court, as it pertains to the heads of argument. Only to the extent it was relevant, whether the legal issues were taken previously and what the ruling was on, and that, of course, is dealt with in the tribunal's award, yes, the appeal tribunal's award. But that's the only point I make. You've taken me to this heads of argument. I've struggled to find its relevance, but I see the point that you now want to make is with regard to the issues of dishonesty in which it was challenged, but that finding stands.
My Lord, if I may then go to the first issue of onus and question of where the onus lies. Your Lordship would see that the initial arbitrator relied mostly on Dugmore, and Yapnoko is also mentioned. And in our heads of argument, maybe somewhat of a theoretical approach, but we submitted that there are 4 categories and so on. But really, Dugmore isn't in our submission relevant at all, because Dugmore deals with collateral benefits. This is now the insurance and the gift that may be given out of pity. And even though Dugmore does seem to say that in respect of collateral benefits, the onus lies on the defendant to show that the benefit was collateral. This doesn't really arise in this case. The case that I would like to take your Lordship to is Yapnoko, that you'll find at our bundle at page 59 and 60, because Yapnoko doesn't deal with the collateral benefit or the duty to mitigate. And if I can take you to pages 59 and 60 of the bundle. And it's unfortunately to go into Yapmoko in a bit of detail, my lord, because it is a case that is important for our side. Your Lordship would have seen the facts there. The SAPS members, the Minister is sued vicariously, of course. The SAPS members intentionally and for their own gain issued these clearance certificates to a crime syndicate that was then using it in order to sell stolen vehicles. So your Lordship would have seen the vehicles are sold from the crime syndicate to an entity called Profit. From there it's sold to Yapmoko. Yapmoko sells to the public. The police then seizes the vehicles, and the public member that bought it obviously now sues Yapmoko, asks Yapmoko for compensation. But what happened was that there was a cooperation agreement between Yapmoko and Profit. And when the minister gets sued, the defense is that you're not entitled to damages because there were some payments made to you from Profit. Yapmoko is told that some payments have been made to you from Profit. We don't know what they are because we are an outsider as the minister, but we're saying there are some payments made, and your Lordship will find the build up to that at page 59 of our bundle, and from paragraph 22. This is the Verweerde se alternatiewe betoog. And if I can just read a few of these passages, it won't, not many, because your Lordship would obviously have read this case, and especially paragraph 22 to 25. I had to read it several times. It's dense. But if one starts at paragraph 22, your Lordship will see that die alternatiewe betoog, dit is die eiser in elk geval nie omvangs as sy skade bewys het nie, aangesien die eiser 'n sogenaamde samewerkingsooreenkoms met Profit gesluit het. En dit het tydens die kruisverhoor van Hatting gebleik dat die eiser sekere terugbetalings van Profit ontvang het, wat Hatting nie kon kwantifiseer nie. And dan gaan it's going further there, and it emphasizes the cross-examination that happened. And then at 665 of the report, this is a long paragraph 22, there they record what was asked. And Hatting, this is now the plaintiff, Yapmoko. Ek kan nie vir u sê, vir ons sê hoeveel dit was nie. Nee, ek sal nou met dokumente voor my kry, dit is ook al lang terug. Ek kan nie spesifiek meer onthou wat die bedrag is nie. And then paragraph 23, volgens die beweerde beteken die stukkie getuies, die verweerde there is the minister, of course. Volgens die verweerde beteken die stukkie getuienis dat die bewys van die eiser se skade in die liggaam. Volgens die eiser is dit alles vanweë die werking van res inter alias akte beginsel irrelevant. Bovendien so beweer die eiser, as die beweerder iets daarvan wou maak, moes hy dit as 'n spesifieke geskilpunt geopper het. In welke geval die kwessie behoorlik uitgepleis sou wees. Nou my mening gaan nie een van die twee redes op nie. So res inter alias actus is of course not relevant, maar dit is die tweede een, the second one is the question of whether it should have been raised specially. En dan paragraaf 25, paragraph 25 over the page. Die eiser se verder betoog dat die verweerde dit as 'n spesifieke geskilpunt moes geopper het, indien hy op die terugbetalings deur Profit as 'n beweer wou staat maak, kan eweneens nie opgaan nie. Die hof akkooi het die betoog aanvaar, ek nie. In die eerste plaas was die kwessie reeds op pleitstuk stadium geopper. In die tweede plaas sien ek dit, anders as die hof akkooi, nie as 'n verskyningsvorm van die algemene reël bedaadele nie vergoeding kan verhaal wat hy redelikerwys kon vermy of verminder het nie. Daardie beginsel is nie van toepassing nie. Dit gaan hier oor die primêre vraag of die eiser die omvang van sy skade bewys het. Nie of hy sy bewese skade redelikerwys kon beperk nie. Ware eise soos hier die omvang van sy skade prima facie bewys, berus dit by die verweerder om aan te toon dat daar sekere voordele is wat die eiser toekom en wat na regte van die skade en vergoedingsbedrag afgetrek moet word. Word daardie feit deur die verweerder bewys of deur die eiser erken, maar die omvang daarvan is onseker, berus dit by die eiser wat beter as die verweerder daartoe in staat is om dit te kwantifiseer ten einde te bewys wat die balans is waarby teenoor die verweerder op taal geregtig is. My Lord, and then just in the judgment of Nugent at paragraph 29, the Lordship would have seen he confirms.
Yes, we gave.
Yes. So there's a double switch, my Lord. If we, it is first on the defendant to show benefits, and then it switches onto the plaintiff.
Plead it.
Sorry, my Lord?
Plead the benefits.
Yes, my Lord. That it's not. I don't put it 100% clear from this that is indeed the case. But we're not going to say we pleaded it.
Good. But you see, I agree with you. Chibmoko, as you say in paragraph, I think it's 59, is decisive. Is that right? 59. One of the other paragraphs. 61. 61. Chibmoko, it is decisive. So the question is, how do we read Chibmoko? And what are we reading and what are we saying? Are we reading it carefully? Because the arbitrator, the appeal arbitrator says Chibmoko doesn't help you. You make the point, no, they're wrong. So let's read it carefully as you've been through it now. Because when I read it, I actually see, you see it's, you've underlined in your heads of argument just a part of it. Your underlining starts, maar die omvang van daarvan is onzeker. So that's where you want to do the underlining, is the quantification. But we get to the quantification follows whether the claim has been made of a benefit. And that's further up. And he said, word daardie feit jy die verweerder bewys, just preceding that, of die eiser erken. Now we know two things. One, it's not pleaded, it's not proved, and certainly it was not admitted by the university. So you don't get to the stage of quantification.
Yes.
That's how I read Chibmoko. It doesn't help you.
My Lord, I think your Lordship put your finger on exactly the problem with our argument. And we of course have to accept that and have thought about that for some time. But the submission we make is, and that's why we prepared for your Lordship that whole part dealing with benefits. And if I just take your Lordship there, because the submission is this: it was never in dispute that there were benefits. It was not in dispute, and it doesn't. It's not in dispute here before this court that there were some benefit, at least in the sense that the expenditure was within the university's scope of business. That is, we say it's two sides of the coin, that the expenditure was within the university's business and that there are benefits. And it's never seriously been in dispute. What was in dispute? Sorry,
never seriously disputed. Okay, I don't have the benefit of 615 volumes of the record, but I look at what's in the pleadings before me here, and the awards by the arbitrators. The respondent says, we've never admitted that there was a benefit.
yes.
We've never conceded there was a benefit. In fact, the appeal tribunal even points out that certain of that expenditure is simply not properly explained, to put it at its lowest and possibly at its highest, where he goes off and spends university money on dances and golfs and wine and beer tents, how can that possibly be for the benefit of the university?
No, we appreciate that, Baloda. That's why, for us, this part now, as far as the onus is concerned, on the first leg of our argument, is the crucial part. And that's why, my lord, if I can take you to the evidence and findings document that we prepared. Because your lordship would see that what we've done is to say that Yaboka would also apply in a situation, regardless of whether you pleaded it, regardless of where it's in fact, it's always been admitted that there were some benefits, and the debate was always about the...
You see, I don't have that record. You can't take me to the record now because I'm bound by the findings. Yeah. So, to the extent that there were benefits, the arbitrator, neither the appeal arbitration says there were benefits. Nowhere in those awards does it say that there were benefits as such, which are not proved.
It comes close to it.
It comes, no, we're not playing with closeness. You know, this matter is not about closeness. I'm going to debate at length with Mr. Bishop later about the whole Shakespearean notion of appearance and reality when it comes to plausibility. We're not dealing with appearances in this matter. And it's not an issue, it comes close. It comes close, therefore there is a gross irregularity. How can that ever be the test? It comes close.
No, my lord, if I may then just take your lordship, if I may, to our document at page 2. The evidence findings regarding benefits, and included in this is, of course, what we also see evidence and findings about whether the expenditure within the scope of the university's business. So your lordship will find in the first 3, this is now evidence on the papers before your lordship.
So just find that note.
Yes. It should have a letter addressed to your lordship on top.
Yes, I saw it and I just wanted to find it.
See, it's numbered at the bottom right part.
Let me just find it. Half a second.
So your lordship would see pages 2 and 3 deals with the applicant's affidavits in the present matter and the respondent's affidavits in the present matter, what they say. So we allege in our founding papers that the reallocated funds, there's of course the reallocation, then the expenditure, then the benefit. But the reallocation of the funds were largely used to provide transformation scholarships to needy students. Let's forget about the careers. What do they say? They just deny that, that the funds were used to provide transformation scholarships in inverted commas. Then we say the next one.
Let's stop there. So did the arbitrators find that these were for transformation scholarships?
No, it didn't consider the issue. But when we're putting it to them now, they say no. We go on to say that the university received subsidies from government for the rugby players who received bursaries from 2003 onwards. They don't deal with it.
Sorry, just assist the court. What does that mean?
And as I understand it, my lord, you give a scholarship to someone, that person graduates, and then the university get paid subsidies from central government for that student.
Sorry, I don't follow.
There's an entitlement to a government subsidy for a student, so the allegation is, I understand it, is that in the founding affidavit is that The university did receive subsidies as a
I'm
consequence.
trying to
of
understand
it.
the concept of subsidies first.
The central government funding.
Yes, but is it to compensate in addition to the scholarship?
Not to the student.
Not to the student, to the university,
Yes.
because the subsidy makes up the difference in the actual cost of the student being at university,
Yes.
other than the scholarship.
Yes.
So the university would have carried that extra cost whilst the student was on scholarship.
Now, with your lordship, but I think the allegation was that if it wasn't for the scholarship, the student would never have studied.
No, but that's not the point. The point is not the subsidies. The subsidies just evens out the expenditure of the university.
Yes, my lord.
So there's no benefit to the university in a real sense, because it would have incurred that expenditure whilst the student was there. Other than the scholarship which would have covered no more than the school fees of any student doesn't cover the full cost of any student at the university. That is the subsidy. The subsidy covers the difference.
Yes.
So that's all. Student was there, scholarship, partial compensation, and then the subsidy.
I suppose the scholarship enables the student to be there because the subsidy wouldn't have been enough for that student. And
Precisely. Well, precisely. So there's no benefit to the university because it would have been a cost it would have incurred.
Yes, my lord, but the university benefits from having the student there and from the scholarship being paid to that student, and that component is then relieved of the university.
No, there's no relieving. So, firstly, the scholarship is equivalent to what would be a private family paying for the tuition or for the hostel fees. But there are the other costs that the university carries with any student being at the university. Its contribution to the total budget of running and all of the other expenses, buildings, electricity, all of that. That is what the subsidy evens out.
Yes.
That's all. So there's no benefit to university if the student has in fact been at the university, got the scholarship, and all the government is doing is to reimburse for the contribution towards its contribution to the running cost of the university.
Yes, Lord. Can I reformulate? It is expenditure within the scope of the university's business. It does give scholarships. It cannot say that that scholarship falls outside the scope of its business. And it's in that sense that it then benefits, because it gives scholarships, and this is one of the scholarships, including for the oorbruggingsprogram that were given.
I accept all of that, but the point that has been made is an attempt to show that the subsidies were a benefit. And the subsidies are not a benefit, they're simply reimbursing the university for actual expenses incurred in the running cost of the student being there.
Yes, my Lord, I can't take it further.
Isn't that the simple logic of it all? So when the point is being made, there's the benefit. It's not the university, the government subsidy. And in fact, just on the point, if you wanted the amount of the government subsidy, when they refused to give it, compel them to give it.
I accept that, my Lord. I'm trying to make the argument that if one looks at the evidence as a whole and the arbitrator's findings, the issue in dispute was always what was the quantum of the benefit. And what we're arguing today is that once it's established, and I must just run ahead because this will be the conclusion.
Yes.
Once it's established that the expenditure was in the scope of the university's business and legitimate in that extent, I'm not talking about the reallocation, the expenditure part. If that's within the scope of the university's business, one must assume that there's a benefit.
You can't make the assumption. You see, that's where they differ with you. They said, yes, you're going to tell us what the benefit is. Yes. You can't just assume it because, university is a huge institution.
Yes.
There are expenses that are made at various different levels.
If I can just take
we told that there's 11,000 cost centers.
Yes. Now, my lord, if I can, in our document, we do say it was pointed out in these proceedings and before the initial arbitrator and the appeal tribunal, that there are benefits and that it's spent in a regular way. Once it reached unlawfully the point of it being in the 4 cost centers, from there on, the expenditure was regular and signed off as such.
Not legitimate.
Not legitimate, my lord. I accept that because of the prior unlawful reallocation,
Yes.
not the second stage.
It was done procedurally, whether there were signing offs, it was paid in accordance with the payment procedures by any department. So, but it doesn't make it legitimate, you see.
Yes, no, my lord. What we're arguing is that neither in these proceedings or there was it ever contended by anyone that that expenditure was illegitimate for any other reason than the reallocation, than the prior
Is that so?
unlawful reallocation.
But it's more than that. It says that the expenditure, simply because it was procedurally done with all the checks and balances, doesn't mean that that expenditure was lawful. That's what they say. It's not admitted that the expenditure was lawful. That's the gist of their case. Both the reallocations and the expenditure were unlawful.
My lord, the one statement that is made that your lordship referred earlier to, if I can take you to our document on the last page.
Yes.
And if I make it overstated, then your lordship will no doubt correct me. But there's one statement about possible unlawful expenditure, and that relates, as your lordship has raised earlier, the question of house dances and so on. But on the last page, you'll see that what the appeal tribunal stated was that some of the funds that ended up in the cost centers of the rugby club found their way into Mr. Roos' personal account. Now, he did explain that at the hearing and also in the replying affidavit, was spent on rental and food for rugby players, travel and subsistence, house dance, and so on. That's stated by the appeal tribunal. But ultimately, when the argument is recorded of our predecessors to say, but those were all regular expenditures as part of the rugby club's ordinary expenses, the appeal tribunal goes back onto the unlawful allocation. So your lordship would see whether the expenditure of the said funds in the manner in which this had occurred would in normal circumstances have qualified as legitimate expenditure by the rugby club overlooks the allocation not been budgeted for and misapplication. So they never found that the second leg, that the expenditure on the second leg after the reallocation, that leg was unlawful for an independent reason, for a different reason than the reallocation. And in fact, we have put this to them, and there's pages and pages of this, I'm afraid, my lord, but we have put on what way was the expenditure component irregular, independently from the reallocation. And we have put it to them in these papers in four different spots, that it was used for university's business, it was legitimate in the sense that the funds were spent on university business, and again and again. And your lordship will see that what we get is, I deny that it was used for university business. They're not dealt with and not dealt with. And when the appeal tribunal, for instance, deal with the argument, we can walk away from the bursaries for a moment, but deals with the argument about the enhancement of the university's reputation in the rugby club. It says as follows, if I can just find it.
It deals with the test.
Yes, my lord. He deals at page 4. Sorry, my lord. At page 4, the findings of the appeal tribunal. It says the appeal tribunal says, thus, whilst it may be so that viewed purely objectively, some of the ultimate expenditure could have enhanced the reputation of Marty's Rugby, the extent of which was not established. The US didn't subjectively choose to spend its fund in that manner. And so one can go through both the initial arbitrator's award and the appeal tribunal's award and these papers. But what one finds is nowhere is it suggested that that second leg, once the funds were secretively or in whatever way reallocated, that there was another irregularity. And of course we say, and I know there's something about the procedure, procedurally correct. This is what everybody says, procedurally correct. But nobody raises the point that it couldn't have been used for that purpose, that the university doesn't give scholarships. But how can it be contended, for example, my lord, that the university doesn't give oorbruggingbeurse?
It wasn't the university's decision to do that.
No, we can't dispute that, my lord.
Yes,
If
and
that's
what
the finding.
The appeal says, no, that's not the choice of the university. It had other choices. Assuming the council sits and says, these are our priorities for the next 5 years, to build residences. How can just giving scholarships be simply accepted that, well, you're entitled to do that, Mr. Roo. Go ahead. Spend it on rugby balls, spend it on dances, spend it on wine. It can't be. Because then you're acting contrary, besides acting contrary to the university's prescripts, you're acting against the universities. Policies where the council determines how money is spent. It doesn't make it right because you decide to buy rugby balls and scholarships when the council might have decided we need to be buying textbooks for students.
Yes, my lord. The argument, however, is this: for purposes of showing a loss or where the onus lies, and we're going now back to Yamoko and so on.
Yes.
That once it's established, as we would submit, it's established here, that there wasn't a second irregularity dealing with the expenditure, that it was within the scope of the university's business and legitimate in that sense. And I appreciate fully what your lordship is saying. Then the onus must switch.
It's irregular. No, it's irregular. Can we accept that the expenditure is irregular?
It's irregular for the purpose of the reallocation, yes.
No, it's irregular because you can't spend on rugby balls when the university's council would have decided in its priorities, we're going to spend it on paying off salaries of academic staff or of workers and cleaners. How can you possibly say that's regular?
No, my lord, it's about the question of where the owners switch regarding benefits.
Yes, no, we're going to find. So we're back at Jabmoko, and as we've pointed out, not entirely sure that Jabmoko helps you.
Yes.
And your reading of Jabmoko is just, you miss a crucial part of that judgment, and you deal with the quantification.
Yes.
All Jabmoko says is that where the quantification, where it's not in the defendant's knowledge exactly what the exact amount is, then the owner shifts to the university. But you got to plead it, you got to prove it to the extent that you can and say, we don't know. Didn't do it.
My lord, as in the founding affidavit, I think in paragraph 3 or 4, we maybe I should just take your lordship. The argument is a bit different. And this is the argument that we try and make at paragraph 5.2. So we're talking about, in the introduction, about an employment relationship. And 5.2, finding that the employee and not the employer bears the onus to establish that a compensating benefit was received for unauthorized expenditure, but within the scope of the university's business by an employee. So the argument is that Jaboco, of course, doesn't deal with every situation, but once the fact is established that this is an employment relationship and the employee, although unlawful, expended money within the university scope of business, then we would say that owners had to switch at that point. That's the only submission of it.
But that goes against your aids of argument. Your aids of argument in paragraph 61 says Jamoco is decisive.
Yes, it sets up, my lord, this issue of a double switch in onus. But we would say in the employment relationship, that first stage is met, that first stage of showing prima facie benefit, not the quantification.
Yes.
That's met when I show that it's in the university scope of business, the expenditure, that equates to the first stage of Jaboco. That equates to it. That's the only argument, my lord.
Yeah.
It's saying that in the employment relationship, I think Mr. Bishop will address it, although I don't want to pass the buck here, my lord. But the argument is simply that it's a different kind of relationship, where unless you recognize that, then whenever the employer spends money unauthorized, and it then has to come and show benefit, that burden would be too high.
But that's not your argument.
No.
That's the constitutional argument.
Yes.
And we'll get that to later.
Yes.
But the point is that the nature of the inquiry relates to the quantification of damages arising out of a breach of contract.
Yes.
Okay. And that's what you're having to address. There's a breach of contract. The determination is damages that arises out of that. And in that context, where does the onus? And you've relied on Jamoco, the correctness in your sense of Jamoco. The appeal says Jamoco has a very different meaning. And if Jamoco sets out what the law is in respect of who is to prove what, then Jamoco hasn't helped you, and simply on the basis of breach of contract, you have a difficulty. To the extent that you now seek to introduce, well, there's a different relationship in this contract. It's one of employer, employee. We'll get Mr. Bishop to argue that and see how he's able to assist the court with that. But you haven't been able to establish it simply because of breach of contract. Jamoco doesn't apply.
Yes, my lord. Of course, I mean, I know it's not entirely answering your lordship's question, but the initial, the awards both, in a sense, of course, the appeal award doesn't deal with Jaboco, but the initial award
No, it does.
is it just says Jaboco doesn't assist.
Yeah, so it means that it agrees with that it doesn't have to go through this debate. I mean, why? I think the appeals tribunal is smart enough to say, why rehash debates and arguments? Just read the judgment. And Nugent's attempt at giving a summary of it doesn't help also. Doesn't help to rely on Nugent J to say, this is what the majority meant. It's not what the majority meant. It's just a complete summation of it.
Yes.
Misses the crux of that paragraph 42 that is so crucial.
May I approach it from a slightly different angle? The initial arbitrator says that in respect of both benefit and quantification, the burden lies on the defendant. That of course is not what Jaboco, but it's not relevant for that purpose. All I'm saying is what should have been considered is in this situation to cross the first hurdle, whether it's not enough that it's common cause or accepted that it's within the university scope of business and it's an employment relationship. That will be Mr. Bishop, and I'm not going to take repeating it. I accept what your lordship is saying. If it is so that you should plead benefit and prove benefit, other than just within the university scope of business, then Jaap Moko doesn't assist us at all.
And where he doesn't know what exactly that benefit is, or he can't prove it, if it hangs up in the air, then the plaintiff notionally in Jaap Moko was saddled with that obligation.
Yes.
That's the quantification amounts.
Yes.
But the establishment of the benefit has to be proved, has to be pleaded and proved.
Yes. And the appeal tribunal, again, my lord, if I've read it already, but they said, yes, it is so that the expenditure, purely objectively, could have enhanced, but you haven't established the extent. And this was what was going on, and I don't mean this, of course, in any disrespect, but it was always a question of, you've got to show how much. How much? What was the benefit and how much?
You're going to show firstly what the benefit was.
Yes.
And then you can tell us how much. But the quantification you're going to be assisted by the plaintiff is necessary as per Jaap Moko.
Yes, although that was...
And remember, what the appeal tribunal says is that it deals with the arguments and then it adds on, it says, in any event. That's not right. In any event, there's the test that we must deal with. And you don't come home on the test because you've not pleaded or proved a benefit. And besides that, there's the second part of the test. University says that's not what we would have spent our money on. It's against the will.
No, my lord, I can't take this.
And so on the application of the test,
yes,
as per the appeal tribunal, what is the gross irregularity that arises out of that in the context of this matter?
If we made the first hurdle, if we on a proper application of the law in the employment relationship crossed the first hurdle because it was within the scope of the university's business, the expenditure, even though unlawful because of the reallocation that happened before, then the owners should have switched and there should have been an inquiry on what the value of the expenditure was for the university. And if it was 35 million or 34 or 30 million, of course, as Jaap Moko says, if it's unclear then you've got a problem as the plaintiff. But if it was proven at that point to be whatever, say the scholarships, that is not acceptable, that the university got any benefit out of it, but there had to be a quantification exercise and the plaintiff, the university, at the burden there. But there was no inquiry ever, as your lordship would know, as to the benefits and the value of them.
So spend a few minutes and talk about what happened in the arbitration. So there comes from Mr. Rulu. Mr. Rulu testifies, ends. The counsel stands up and says, we're going to call an expert now on the benefits. And there's a discussion about the time and all of that. And the university says, hold on, you haven't pleaded it, so we're going to object. The arbitrator says, well, because of time, let's just deal with this evidence and I'll make a decision later on in my ruling with regards to whether it's admissible. And the university says, hold on, if you leave the evidence, we will have to cross-examine. If we cross-examine, we need to have our own expert. It's not going to finish off in the next couple of days. And then the arbitrator says, fine, you go and discuss amongst yourselves how you're going to deal with this. Tell us tell the other side if you're going to call this witness, and then we'll deal with it there. The arbitrator doesn't make any ruling adverse to the applicant. In fact, initially tries to accommodate the applicant. Says, I'll make the ruling later. The applicant's counsel then says, well, we also reserve our rights with regard to an amendment, assuming the pleadings with regards to whether there's a benefit or not. But that's not taken any further. It's not, but that was open to, it was open to the applicant. Overnight, the applicant comes back and says, no, we're not calling this witness anymore. There's nothing in that procedure that indicates that the arbitrator had acted in any way against these interests. Procedurally fair, gave him the opportunity of overnight considering it, would have even have given him the opportunity, I suspect, if the proper application was made, for an amendment. It would have been opposed, but there would have been cost implications to that. There's nothing in that procedure. In fact, what the arbitrator does is to, in fact, deal extremely fairly with both sides. Doesn't impose his position, doesn't even impose his ruling on onus at that stage. Doesn't even say, well, you know what? You can't call these witnesses because you haven't pleaded it. And now you want to call an expert. There's nothing unfair about that. Again, the point I make is there's nothing unfair in which the arbitrator dealt with the applicant relating to his adducing any evidence on benefits. Is that correct?
My Lord, except for this, our argument is, and I take your Lordship back to the conversation about that your Lordship, or the submissions that your Lordship made now. Our argument is, at that point, the actual witness wasn't called about benefits or expenditure within the scope, but was called about quantum. It's called about quantum, that's our argument. And your Lordship will see in our little summary, we recorded there what Advocate Fagan was saying at that time. And if I can find, your Lordship would have seen it. Advocate Fagan at page 3. He's saying, at the bottom block there, Advocate Fagan, you know what our position is. We say there is benefit, and this is a quantification of that. And then earlier, Advocate Fagan at the hearing before the initial arbitrator, the objection is because we have merely denied the allegation of damage. We haven't expanded on that, but that precludes us from leaving evidence as to what value this rugby club initiative and so on they've had. And then the appeal tribunal as well. Yeah, we acknowledge that there would have been a reputational enhancement, but it hasn't been quantified, the extent of which wasn't established. And then they go back onto the reallocation. So the submission is simply that, is that if at that stage it was truly about quantification, and it was common cause that it was spent regularly as the arbitrator recorded, the expenditure was regular.
It's not common cause. But you see, you make the jump. And this is why the other side's going to cross swords with you for a long time today about what is assumed to be common cause in these proceedings and what is not. But the important thing also is that whether Mr. Fagan says, we say this, we say that, where's it pleaded? It's not pleaded. The benefit is not pleaded. And the discussion I've had with you, the simple answer is that was there anything unfair with the way the arbitrator had conducted those proceedings?
But what if at that stage, I need to get to that. I don't want to stop the debate at all, but
isn't that a fair question to pose? It's a fair question to pose. If you don't want to answer
no, of course,
you can say Mr. Bishop will answer it, and Mr. Bishop doesn't answer, then you know. It's a simple answer.
I will never.
Was there anything unfair in the procedure, in the way the arbitrator had conducted the proceedings, with regards to the leading of any evidence.
Other than if at that point the arbitrator should have said, we've crossed the hurdle, the first hurdle on Yatnoka. I accept that there are benefits because nobody here is contesting that the expenditure was regular, i.e. ordinary, normal.
Yeah.
And therefore, if we're going to go to benefits, they shouldn't have pleaded it. You should have pleaded the quantification of the benefits now, and that it doesn't amount to the full 37 that you claim.
But there's nothing that the arbitrator did to prevent the applicant from properly conducting his case. He didn't do it. They made a bad choice overnight, a strategically, a tactically bad choice. Might have been different if they had let the evidence and now we sit hindsight. But they made the choice. They elected the procedure they wished to adopt. The arbitrator couldn't have said, hey, hold on, do you seriously want to do that? It's not for the arbitrator to conduct how you want, what evidence you want to lead. Besides that, they made the choice, made a bad choice. Oof.
Yes. Quite, my lord, I'm going to leave it there if I may.
Okay.
And go on to the special general damages,
Yes.
which is it's a much shorter debate. And in fact, your lordship will not find in your bundle that we photocopied those cases, Holmdien and the Snow Crystal case. But they fully quoted in, I know in the heads of argument filed in the appeal, your lordship will find that at page 205 of this record. The firstly, Holmdien, page 205. And then over the page is the Snow Crystal case. But it seems to be that Holmdien is talking about the kind of breach of contract. The lordship almost in the middle of the quote, those damages that flow naturally and generally from the kind of breach of contract in question, which the law presumes the parties contemplated as a probable result, and the special damages being too remote. And then over the page, the reformulation in Snow Crystal that talks about the subject matter and the terms of the contract itself. So the subject matter we would submit would be similar to the kind of breach. So one is dealing really here with the subject matter / kind of breach, and then the terms of the contract itself. If your lordship just page a few pages back to 203, this is the argument that was made then and which we adopt now at 203, paragraph 72. This is the kind of breach that we're talking about, which is that according to the introduction to the guidelines, the rules and regulations contained in the university's financial policies are applicable to all financial activities and transactions within the university environment. This introduction continues and then to say it's a duty of each person to ensure that he or she acts in these rules and regulations. Any person who does not act within the rules and regulations will face disciplinary action. So the contract of employment or the breach was a breach of a generic obligation to respect the guidelines and the rules and regulations. That is the generic type of breach. And the second leg which is the subject matter, is a kind of breach is unauthorized expenditure
albeit within the scope of the university's business. And I'm not repeating that, it's just unauthorized expenditure. So those two, if one looks at the terms of the contract, this is a generic obligation on everybody. And then secondly, the kind of breach which is unauthorized expenditure only. We would submit that in the employment context, that requires the plaintiff, the employer, to show specially why that was within the contemplation of the parties. This type of damages claim was in the contemplation of the parties. And here again, my Lord, I know that Your Lordship earlier said that there was findings of dishonesty and so on, but it doesn't do work here in this debate because the university didn't plead it like that. We can point the fingers the other way for once, my Lord. They didn't plead, you, Mr. Roux, is a very senior, we give only you the keys to the safe. And for that reason, this is general damages out of this particular employment contract. Or it was always in the contemplation of the parties that if you dishonestly move, therefore, they pleaded it just to say this is this generic obligation and the kind of breach alleged to be is unauthorized expenditure, nothing more. And I'm not going to take Your Lordship back to the appeal tribunal. They record what was pleaded, the nature of the breach, but there's no allegation there of dishonesty and so on. And Your Lordship, we can well imagine that if that was an allegation made to say that because you were dishonest in the reallocations, therefore it's general damages because that's implicit in.
Now, how does that amount to a gross irregularity?
My Lord, that's the second exception, no, sorry my Lord, the third one that I mentioned in the beginning of Concordia, where there's a jurisdictional fact almost missing. There's a jurisdictional fact missing because if it is special damages, that was a jurisdictional fact required to be pleaded and proven. Lord, the next topic is preemption. I just saw, I'm not sure that it's persisted with, I saw a one-liner in the heads or maybe two lines. I don't get a reaction, so I suppose it is persisted with, but I'll be brief. Your Lordship would see on the preemption argument, the university relies on a case called Venn Mop, but that judgment doesn't deal with a constitutional court's much more comprehensive judgment that we refer to in our heads of argument, the judgment of then Chief Justice Mogoeng, that Your Lordship will find at our heads at page 147. Sorry, it can never be page 147, paragraph 147, yes. This is the case of SARS versus the CCMA, paragraph 147 at bottom of page 72. Preemption, there's three requirements that Your Lordship will see here. 26, it must leave no shred of reasonable doubt about the losing party's self-resignation to this unfavorable order. Then another passage on the next page, 73, the conduct relied upon must be unequivocal and must be inconsistent with any intention to appeal. And the onus of establishing that position is on the party alleging it, i.e. the university head. And 3 at the bottom, he brings into the context the interest of justice as well. So those are the 3 things: no shred of reasonable doubt, unequivocal, and the interest of justice. Now, I'm not going to take your lordship to the letters, but there are 3 letters that is the exchanges between the dates of 9 December 2021, then there's a response on 17 December, and then another response on 17 January 2022. And your lordship will find the first letter, which we didn't annex to our papers, but it's next to the answering affidavit. Sorry, I see I had something else to say before that. And this is that the context within which this happens is explained in the replying affidavit, because the point is taken in the answering affidavit. And the context within this happens, your lordship will find at page 323, which is a context where Mr. Roux now fears sequestration your lordship would see 25.2 at the bottom of 323. Maybe it is worth it to go through the letters, my lord. I'm sorry, I think it is probably better. But at 323 at the bottom, 25.2, if the appeal went against him to immediately move for sequestration, he's worried about immediate sequestration. This is what is explained here by the attorney, but confirmed by him. Then we go to page 298, which is the first letter of 9 December, which is a letter about a meeting. It's a letter from our attorney to university's attorney at 298. He says, we actually congratulate him with the appeal. And then, ek sal graag met jou gesprek wil voer oor die pad vorentoe besonder nakoming deur die jury van die toekenning. So it's the main point about this letter is he wants to meet. He wants to meet, that's to discuss things. Then, my lord, we go to the next letter of 17 December 2021 at page 278. This is now next to our papers, 278. Now, the response from Mr. Hill isn't to say, oh, well, I see that you don't want to dispute this any further. That he talks about the request to meet. And you will see at the second, I refer to the telephone, I met with my client today to discuss your request for a meeting, and then records the 3 preconditions for meeting. And then just the next page, over the page 279, the response to that is where Mr. Erastus say, well, I don't agree with the preconditions for the meeting, but anyway, I will take instructions on that, which implies that he never had instructions to engage with that on the first letter, on the 9 December letter.
So why did he want to meet?
To discuss some kind of a way of avoiding sequestration. This is what we're submitting the law.
But if this is what the letter says, the letter says you want to make a proposal with regard to payment.
Yes, my lord.
So where does the issue of sequestration arise? Other than in reply or
My lord,
whatever else?
No, in the replying affidavit, it's contextualized to say that this was the reason why that approach was made immediately, because he feared that if he was sequestrated, he was going to lose his job, and then also.
No. Your attorney writes and says, we want to meet to discuss a proposal of payment.
Yes.
Payment proposal of the award. Nothing else. Nothing to award of sequestration or. That's it. How did we get to anything else?
My lord, because what he's doing, we would submit, is to say, one option that I'd like to consider is if such a plan can be agreed upon, which would save sequestration, save me from this result, then I would consider that as an option. But the biggest submission is, my lord, it simply doesn't meet the test, doesn't go unequivocal, doesn't go without a shred of doubt, and certainly not in the interest of justice, we would submit in this case, because simply this. I mean, it's apparent from the last letter that Mr. Erasmus records that he will still take instructions on it. So if someone is now going to be preempted from the review, when it's clear that he didn't give those instructions.
Sorry, but he must have, just the logic of it is that he must have been given instructions with regards to the matter. And the matter, in his mind, would have been, well, I've got to make an offer of payment, as opposed to simply saying, Mr. Hill, we're taking you on review. You know what? It's December. Can we agree to file these papers in February? And isn't that the logic? I mean, if he had instructions to go on review, you'd have said so in that letter.
Yes, my lord, but at that
and
stage,
that also would have warded off any sequestration proceedings.
yes.
The lawyer would have told him, that's the advice we give you. You're in a ward of a sequestration, let's just take this thing on review. Why must you now go and make an offer of payment?
He wants to meet, my lord, that's
Meet to do what? To discuss payment terms.
Yes.
That's it. Not to discuss a review, not to discuss ifs and buts about the award. Wants to make an offer of payment. At that stage, the instructions are that there's no review on the table. In fact, he doesn't even tell the other side. We're even considering whether this matter should be taken on review.
Lord, we would submit that there is doubt in this case as to whether those three letters can be construed as unequivocal in that sense, that you accept the award in that sense. And that's a submission, my lord. I can't take it further. The Venn Mop case that they rely upon is where the proposal is actually to make a down payment, say, I'll pay you this immediately. It's not me to discuss what was clearly in the, we would submit not clearly, but there's doubt as to whether it is a preemption situation, whether it's discussion, meeting to discuss an option for Mr. Wu. And that's a submission, my lord. And now I really don't know on the further leg of ulterior motive, whether I've got addresses. That really isn't addressed in their heads at all. And maybe I'll deal with that then in reply. On the issue of the extension of the 6-week period, we set out the test in our heads at page 64. With reference to Safcol and York Congress. And again, the term good cause for the extension is used in section 38, but also in section 32, is a term of wide import. Good cause, that of course covers the terrain. Of relevance is the relative prejudice that the parties may suffer, and obviously the explanation. We'll just address you on the last two, the relative prejudice and the explanation. But obviously the prejudice to Mr. Roux is potentially severe, and to the university less so, we would submit. As to the explanation, your lordship would see the 6-week period ended on 20 January 2022. And the review was instituted on 3 March 2022. So there's a period of 42 days delay, roughly 6 weeks. Period is 6 weeks, the delay was 6 weeks. We make the following 4 submissions. To get to the 42 days, we submit that firstly the period between 9 December and 17 December, there was an attempt to settle the matter. That's 8 days. Then from 24 December to 3 January, we submit that those festive days really can't be counted. Those are 8 days. Sorry, my lord, 10 days. Really between 24 January and 3 December, one cannot take that period into account. That's 10 days. So we're now sitting on 18 days. Then from 19 January to 24 January, our attorney, for what it's worth, then 78 years old, at COVID. I think 5 days is a bit short, but it is another 5 days. And then finally, we submit that the need to get an opinion on the constitutional aspects. Yes, we say 3 weeks wasn't an unreasonable time for that. But in fact, it's only 19 days, so 2 weeks and 4 days. So if one takes the full period of 42 days, we submit there's the attempt to settle, for which we provide an explanation. There's the festive period, there's the COVID, and then the opinion. Those are our submissions, my lord, on that. There's nothing else for me, my lord.
It's just one nagging paragraph in the heads of argument. Yes, it's the quote of paragraph 62. What is being said there?
Yes. I'm the author of that, my lord, so.
Please help me.
It's a situation where, almost like the Constitutional Court judgment in Lefudu, Your Lordship would see Justice O'Regan is saying there that arbitration proceedings sometimes one needs to appreciate that they're not as formal necessarily. I'm not saying that they shouldn't be, but in a situation where it's clear that there is a benefit around here. There is a benefit around. Why are we now going to decide this case simply on who bears the onus? It is one of those calls, you're either right or wrong. If you're wrong, then the award is in danger, possibly. If you're right, then it's fine. Why not at that stage say, I'm not sure who bears the onus here. It's a tricky situation. And can I just hear the evidence on what quantifies, what quantity of value those benefits are? I don't want to refer this to Mr. Bishop, but it's a situation where we feel that there should have been a call to at least get that on the record, instead of saying formally, you should have pleaded this and you should have proven it. In running a fair arbitration.
No. I'm sorry. We're going to reverse now, because I asked you very specifically what in these proceedings were unfair. You've not answered that, because I assume the answer is in the affidavit, the replying affidavit, not complaining about the procedures being unfair. But the point is, you know, after us having gone through the exercise of what did the arbitrator do, what did the arbitrator attempt to accommodate, your client was given the fairest opportunity of even considering overnight what its position would be, what evidence it would lead. It came back the next day and says, we're not going to call any evidence. And the respondents saying, well, that's it. So all our objections in that, which we would have raised, we would have argued, we would have asked you to listen to argument on whether it was pleaded, whether they're entitled to call experts. All of it doesn't have to happen. Now you're saying that the arbitrator should have, of his own, decided, well, let's hear this evidence, irrespective as to whether they want to call it, the applicant, and the objections by the respondent. If ever there was an irregularity by an arbitrator, that would have been it.
Yeah,
Imposing his will on the parties contrary to what they want to do. Really, I don't understand 62. And 62 says, well, there's a role of facilitating by the arbitrator. So arbitrator is not there to facilitate and to mediate the relief or the procedures. I don't understand 62. And if 62 is an attempt to raise the issue of fairness, I'm not too sure it does. But anyway, I thought I'd raise that with you in fairness because you asked me if there's anything else.
It is one of those but even submissions, my Lord, at the end of this component. Lord, those would be my submissions.
Yes. Good. Mr. Bishop, are you ready to go, or should we take a tea break, or how long are you going to be?
I'm in the court's hands, my Lord. I had planned to be about half an hour. I've had some more work put on me, but I don't know if it'll be more than half an hour, I hope.
Certainly. Should we proceed, or if anybody wants desperately to take a tea break? Can we soldier on? Thank you. Thank you, Mr.
If I can begin with the question you raised about Rule 16A, because it's an important point. We haven't filed the notice. I think the reason is that the relief that's sought isn't directly constitutional relief. It requests the setting aside of an arbitration award, and then requests this referring back to the arbitrator to consider the development of the common law. That's the prime relief sought in the notice of motion. It is true that in the affidavit we also said that this court might itself develop the common law. So I think your Lordship is correct that a Rule 16A notice probably should have been filed.
Well, it's a constitutional issue you raise.
Yes.
You can't stand up now and say we're not raising a constitutional issue.
I accept the motive. If I can suggest the procedural way to deal with the problem, because a similar problem confronted acting Judge Rogers, who he then was, in Shelf Play. If I can give you the reference to the case. Now, it's just the procedure for how to deal with an instance like this, where the court is now at a hearing and it's raised whether by the court or the other party that there hasn't been a Rule 16A notice. The citation is 2012, Volume 3, South African Law Reports, page 441. It's a decision of this court, and it's paragraph 6. So the same thing happened there at the commencement of the hearing. One of the parties raised that there'd be no 16A notice, and the procedure that Justice Rogers adopted was to say that the notice had to be filed immediately, and the court would not issue its judgment for 20 days, which is the time in the notice for any amicus to come in. And so that would give an opportunity, if there is an amicus that wishes to participate, it would come in. If that happens, the court will then issue further directions for the hearing of it. Because the problem is, if this court now postpones the matter, and then we have to issue a Rule 16A notice, and then no amicus comes, we'll all be back here anyway, making the same arguments to your Lordship. So it seems that might be, and your Lordship could give that directive today, might be the appropriate procedural way to deal with the problem. As the court pleases. Well, so my part...
I'm just curious. Why did the applicant not think it was necessary to do so? You're raising what, on your argument, would be a fundamental shift in employment law.
Well, I'm not sure we accept it would be a fundamental shift, but yes, it would be a change. My Lord, honestly, the matter was not considered. It was an oversight. It should have been done. I think because of the nature of the case, and my letter to Mr. Duval pointed out.
Well, I think the nature of the issue raised is plausible.
My But it is what it is, and it seems that's the best way to deal with it going forward.
But it just seems that that's why the reason is it's no more than a plausible argument being raised. But we'll debate that.
Yes, my lord. No, so our argument is whether there was an obligation on my part of the argument, whether there was an obligation on the arbitrator and the appeal panel to develop the common law, at least to consider whether the common law required development. And we submit that raises 4 issues. The first is, did the arbitrators have the power to develop the common law? If they did, can they or must they, when it's not pleaded by the parties, because we accept it's not pleaded. Thirdly, if there are circumstances where the arbitrator was obliged to develop the common law, consider the development of the common law, would that amount to gross irregularity if those circumstances were present and the arbitrator did not? And then fourthly, if that is the case, were the circumstances present in this case? Lord, we accept this is a novel argument. We haven't been able to find precedent where a similar argument has been raised. But we submit it's an important one, because at the heart of the argument is that the Constitution regulates all private relations. And it regulates all disputes, or all manners of resolving disputes about private relations. It's not limited only to courts. It must also infuse the way that arbitrators resolve disputes under the common law. So if I can deal with the first issue first, do arbitrators have the power to develop the common law? We don't understand our learned friends to dispute that in their heads of argument. They don't take issue with the question that, in principle, an arbitrator can develop the common law for the purposes of resolving that dispute. Obviously, it doesn't have precedential effect. So I don't intend to belabor that point. It's dealt with in the heads at paragraphs 76 to 84. But unless your lordship has questions about that issue, I'll move on in the interest of time.
Every time an arbitrator makes an award, even though it's inter partes, it's applying the common law.
Yes, Lord.
To the facts.
Absolutely.
So
it must then have the power to develop it if necessary under the Constitution. And 39.2 applies to tribunals as well as courts.
But every time it applies the common law to new facts,
yes,
it's in a sense developing it to the facts.
Yes, that's our argument, Lord. And then there's no difference between that type of development and any other type of development. Development is development.
Yes, but your development here is that the development has to occur because it must be, in terms of 39.2,
yes,
it must aims the purport and the objectives and the spirit of the Constitution.
That's correct.
That's where your nub is.
Well, I will get to the nub, but if I can just take
okay, I'm just saying that,
yes,
you know, it's one thing for courts every day to be sitting. Yes. Every time the court sits, the court's dealing with the common law or
yes,
statute or constitution, and it's applying it. Yes. That's a process of development. Yes. But here your complaint goes further. You're saying that this court should have, the arbitrators should have, because it's not in accordance with the aims, the purport, yes, and the spirit of the Constitution. That's the hurdle you have to get across.
Well, I think that I agree, my lord, but there's a first hurdle, which is the fact that this wasn't pleaded. So the point is taken by the respondents, and they refer to the Everfresh matter, that development of the common law must be pleaded. But we submit that's not the case. We've referred to Carmichael, and I don't need to take a lordship to it. It's at paragraph 39, page 8.
Yes, and the complaint really there is when it's taken up so late.
Yes.
And the Constitutional Court doesn't have the benefit,
yes,
of the thinking of other courts.
Yes, that's right.
This is different.
Yes, because
I don't have the thinking of the arbitrators, but other courts might well have the benefit of my view on it.
Yes, that's correct. And also, one of the alternative reliefs that we seek is referral back to the arbitrator, remittal, which is what happened in Carmichael.
Yes.
The matter was remitted. Even in Everfresh, the case my learned friend relies on, they refer to paragraph 52, which is at page 132 of their bundle. That's the majority judgment of Moseneke, DCJ. We said litigants who seek to invoke the provisions of section 39.2 must ordinarily plead their case in the court of first instance. But if you look then at the judgments, both the dissenting judgment of Iku, which had support from Furman Mocheng and Kiani, where he finds that in this case it should be remitted because in these circumstances there was an obligation on the High Court to consider whether to develop or not. And that's at paragraphs 30 to 32. If I can just take your lordship there briefly, of the respondents' bundle.
Sorry, what page?
It's, sorry, page 130. Paragraph 50. Do you have more?
Yes, thank you.
So I accept this is the dissenting judgment. I'll take your lordship in a moment to the majority judgment. But what the Yaqub J says is another consideration is this: the fact that Section 39(2) of the Constitution has been ignored by the High Court and possibly by the Supreme Court of Appeal when its relevance was by necessary implication brought into sharp relief does add considerable complexity to the equation. And then quotes that passage from Carmichael. And then in paragraph 31, this passage shows that while the courts have a general obligation to develop the common law, courts need not conduct this exercise in each and every case that comes before them. However, there are indeed cases in which circumstances would oblige a court to raise the matter on its own. On the other hand, there are other cases in which a court would not be obliged to enter this terrain. The extract is also authority for the proposition, in my view, that where it is implicit in the applicant's case that the common law had to be developed, the court must consider whether the existing common law, in regard to Section 39(2), requires development in accordance with these objectives. So that's what Yaqub J says. And then what Moseneke J says is that paragraph 76 on page 136. So here the court is considering whether it should be remitted to the High Court, which is the order that Yaqub J gives. And he says, I can find nothing that justifies requiring the High Court to embark on an adaptation of the common law of its own volition. Unlike in Carmichael, here the High Court was not confronted with an egregious violation of a collection of vital fundamental rights, which could not be vindicated when the High Court felt bound by existing precedent to grant absolution from the instance. Moreover, unlike here in Carmichael, there was no doubt that had the High Court developed the common law of Gillett and heard evidence on trial, the claimant had clear prospect for success in her claim. So the point really, my lord, is this: there are cases where the court must, of its own volition, consider the development of the common law. Precisely what is that category of cases where this obligation arises? And we submit from the reading of Carmichael with Everfresh that it's really two. It's where, by necessary implication, the development is raised, or, as Moseneke pointed, where there's a violation of rights that cannot be vindicated on existing precedent. Or where there's no doubt that had that tribunal considered the development of the common law, it would have affected the outcome of the claim. So I don't suggest that those are clear categories, but those are the types of conditions. And I think the best reading is it's a case-by-case question. Is this the type of case in which the arbitrator, the High Court, was obliged to consider the development of the common law? So accepting that there is that category of cases, if those circumstances are present and the arbitrator doesn't do that, is that a gross irregularity in terms of Section 33(1)? My learned friend, Mr. Duval, took you to Telcordia, and I don't need to belabor the point, but I did just want to take your lordship to one passage in Telcordia, because I think it makes the point appropriately for my purposes. It's at paragraph 77 on page 18 of my learned friend's bundle.
Page again.
Page 18, paragraph 77. So the essay is quoting there from the decision in US de Lithium. And that second paragraph of the quote, at the letter G, where Hoekstra J said, the present case differs from cases like Goldfields Investments, in which the result of the wrong interpretation of a section in the relevant statute was that the magistrate never directed his mind to the issue, which in terms of the statute, it was his duty to decide. So where there's an issue that you had a duty to decide and you don't decide it, that is a gross irregularity. And so our argument is not that in every case, unless an arbitrator says, I have considered the common law and I decide it does not need development, if the arbitrator doesn't put those magic words in their award, they're reviewable. That's not the argument. The argument is that there is this category of cases identified in Carmichael and Everfresh where the obligation to develop arises. if that obligation exists in a particular case, and the arbitrator does not at least consider development, that is a gross irregularity because you didn't apply your mind to an obligation that rested on you. So we can test it this way. So if a party had pleaded development of the common law, for example, and the arbitrator had said, I can't do that because it falls outside of my jurisdiction, that would clearly be a gross irregularity. Similarly, if there was a statute that said, when you're taking this particular decision, you must exercise the discretion, and the magistrate or the administrator, whoever it is, doesn't exercise the discretion, it says, I'm not going to exercise the discretion, that too would be a gross irregularity because you haven't done what you were supposed to do. It's not about the outcome, it's not about whether you're right or wrong, it's about the process. And so what the failure here, we submit, and I'll get to why the circumstances existed in this case, but if this is one of those Carmichael cases, then the failure to consider it, to ask for the party submissions on whether there should be development or not, was a gross irregularity in the process.
You see, in Carmichael, it was the egregiousness that jumped out at the court. It jumped out at any court. Should have. It's egregious in this matter.
Well, so let me get to that. So if we've crossed those hurdles. If you accept that if this was such a case, then there's a gross irregularity, then the question is this such a case? So at the outset, just to emphasize the point you made, my Lord, this is a case of development of the common law under section 39.2 in terms of the spirit, purport, and objects. And the court sets out in K, I don't need to take your lordship there, but it's K at paragraph 16, quoting from the Thebus judgment, that you can have development both where there's a violation of a specific right and where there's no violation of a specific right, but the common law is inconsistent with the spirit, purport, and objects, the objective normative value system. So, Lord, I think to understand, it is important to start with the pleadings and in front of the arbitration to understand what were the disputes. And your lordship had a debate with my learned friend Mr. Duval about this, and I think it's important just to clarify it, as I understand it, as I read it. So the first point is, what was SU's argument for why it had suffered loss? So I think what's useful about the heads of argument from our predecessors in the arbitration is that they show how, at that stage, Mr. Roux understood the arguments and the arguments he presented to the appeal panel. And he, in those heads of argument, you can see at paragraph 30, it's on page 186, that initially Mr. Roux took the view that the university's argument was only about allocation. As soon as it had gone from the reserve to these other cost centers, he said, well, the university is saying that now on its own constitutes damages to which they're entitled to loss. And then he said, well, even if that's not right, well, then the case is once it's expended.
But that was wrong anyway.
Yes.
So if that is wrong,
yes.
If the heads of argument is wrong, it's wrong.
Yes.
If he misunderstood the case,
exactly.
How can it be a constitutional issue?
No. I'm just making the point to say that what really the case was, SU's case was in fact, was that it was a misallocation from the reserve cost center to the other 4 cost centers, plus the expenditure of the money out of those cost centers.
No, there was a lengthy, as I understood it,
yes.
In the arbitration there was reams and reams with dealing with the issue of authorization, because that was in dispute.
Yes, that's right, the authorization, but that goes to the...
So no, it was authorization, but it was not the case simply of SU that the expenditure was lawful.
No, I'm not saying that the expenditure was lawful. I'm saying that SU, the university accepted that it had to show that those monies were expended. That out of them. I'm not saying that it accepted they were lawful expenditures.
Yes.
But that the money was in fact expended.
No, but
it didn't just sit in Marty's running cost account.
Mr. Bishop, the point is, as I understood, the issue about the initial arbitration was that the university had simply sought to prove the unlawfulness with regards to the allocations.
Yes.
Not with regard to the expenditure. In fact, the head says he then makes this jump on appeal to say it's also the expenditure, yes. And that's why the appeal tribunal then found. That's not correct as I understand it, because it was raised besides the allocations, there was also the unlawful expenditure. That was the case.
No, I'm with you, my lord. We're on the same page. I'm just saying that that was the case. And that SU accepted it had to show the expenditure. That was part of its case, to show expenditure. That's all. It's a very simple point. We agree with each other, my lord.
No, we don't.
Well, I'm saying that the SU, there were two parts to SU's case. The money went from the central reserve fund to the other cost centres, and then it went out of those cost centres, and therefore it must be repaid. That was the SU's case.
And it was, the expenditure was unlawful.
No, I accept that was SU's case. That was the finding of the appeal tribunal. I accept all of that.
Because that's not what Mr. Deval argued.
Well, I accept that's what the appeal tribunal found.
That's what Mr. Deval argued earlier.
Well, that's not. If you read, I mean, it's at page 143.
Yes.
Where this is the appeal tribunal, where the appeal tribunal deals with the argument and says, however, whether the expenditure of the said funds in the manner in which this had occurred in normal circumstances have qualified as legitimate expenditure by the rugby club of its funds, overlooks the following core points: that it should never have been in those cost centres, and that the university never gave permission for it to go to those cost centres. Therefore, whatever it had been expended on, out of those cost centres, it doesn't matter what it was spent on, it was illegitimate expenditure. That's, as I understand it, the holding of the appeal tribunal. It could have been spent on buildings. It could have built a new pavilion for the rugby club. It would have been unlawful expenditure. Or it could have bought rugby balls or wine or golf, whatever it was, it doesn't matter.
Now,
All that is,
do you accept that that's not what Mr. Deval argued earlier?
well, I'm not sure what Mr. Deval argued about. What
Well,
the
you were
appeal
right
tribunal
there.
actually
So you were
found.
sitting right there. We had this lengthy debate about whether the illegality only arose with regards to the question of the to the allocations, as there's no finding that the actual expenditure was unlawful. You're
Well,
not accepting that the expenditure was unlawful.
No, sorry, my lord. I think that there's two. I understand what the appeal tribunal found, but I think if you read it, and I think this is the point that Mr. Deval was making. If you read this passage, paragraph 30, where it says the expenditure of said funds in the manner that this had occurred would, in normal circumstances, have qualified as legitimate expenditure of the rugby club, and that's the same finding as the arbitrator. Page 61, paragraph 28, where the arbitrator says the spending of these funds occurred, for the most part at least, procedurally correctly in the sense that the procedure required by the university for the expenditure of funds allocated to cost centres was followed. And what the arbitrator and the appeal tribunal says, that's fine, it doesn't matter. It was still unlawful. That's what they hold. But they don't. But the case, the outcome is premised on the idea that even if it was completely procedurally correct, once it got into the cost centres and then got out of the cost centres, that procedure was followed and it was for.
So, sorry, Mr. Bishop, it's very simple. I understand it.
Yes.
That when there's money in a cost centre, the actual expenditure of that money has to go to certain procedures.
Yes.
Okay, so it might need a double signature, it might be on a folio, it might be on an invoice
Yes.
or quote. All of that was done procedurally.
Yes.
Okay? The arbitrator says it doesn't necessarily make the expenditure lawful.
Yes. No, I accept that. We're on the same page.
Yes.
But I'm not saying I agree with her. I'm saying that's what the arbitrator held.
No, but you've accepted that that's what the arbitrators found,
Yes.
that the expenditure wasn't lawful.
Yes. Yes.
And the university never accepted
But if
that
the
the expenditure was lawful.
The expenditure wasn't lawful only because the money shouldn't have got from the reserves to the cost centres. And that taints whatever happens after, it's tainted by that.
You couldn't spend the money, period. It's unlawful. How else could it be lawful?
But, my lord, the question is not
You
only
didn't
about
get
whether-
permission afterwards to spend it,
But the,
or it wasn't ratified ex post facto, so it was unlawful. It's the only way it could have been unlawful. If there was an ex post facto ratification, it was not so.
But no, the point for my purpose of my argument is not whether it was unlawful or not lawful. The
Yes.
question is, what were the damages that were suffered by the university? Merely because the expenditure was unlawful doesn't mean they suffered damages. It could have been unlawful expenditure that caused them no loss. And that's where the debate is, really, about what damage Mr. Roux caused to the
So
university.
you're going back to the benefits argument.
Well, in a sense, yes.
Okay, so he argued part of yours, you're going to argue part of his. I think
well,
that's fair.
But no, well, I mean, the way the case out, and I think you put this to my learned friend Mr. Deval, is that both parties decided that they were going to plead their case and argue their case in a particular way. The university took the view that all it had to show was the misallocation and the money that came out of those cost centers. It didn't have to show anything else. It was then entitled to the 37 million. Mr. Roux took the view that no, it was for the university to show actual loss. And if it didn't, it's not entitled to anything. Right? That's the view that the parties eventually took. There was some debate, as you talk about with the witness, but that's where it lay at the end of the day.
Yes.
And so then it turns on the onus. It turns on where is the onus.
And this was based on the law, as it stands.
For my purpose of my argument, I accept that they got the law correct.
Jamoco, an application of Jamoco, that's what the law is.
My Lord, Mr. Duval has dealt with Jamoco. I'm going to accept for the purposes of development of the common law that the arbitrators got Jamoco correct.
Good.
So that's the premise for my argument, without saying that Mr. Duval was wrong in his analysis of
Well, okay.
So our case really is, well, when you're deciding this question, which is going to determine the entire case, really, which is where is the onus, that's the fundamental question, that was there an obligation to consider whether this common law, we've read Jamoco, we've decided this is how it comes out, is that consistent with the spirit, purport, and object of the Bill of Rights? Was there an obligation for the arbitrator to consider that?
No.
Was it one of those category of cases?
Right.
Now we've got to the nut, my Lord. But
Let's get to the nut. Yes. Spirit, purport, objects. Tell us in the Constitution.
Right, so
spirit, purport, objects.
Right, so we refer to two rights. The first is the Fair Labour Practice Right, in section 23.1, and the second is the right not to be arbitrarily deprived of property, in section 25.1. So I'm going to start with the Fair Labour Practice Right. So just some preliminary...
You're starting with the unfair labour practice.
Yes, I know, I'm doing it in the reverse, but the head you do it the other way around. I'm going to do it this way.
Okay, so let's do it in the reverse.
So there's just three issues up front about the nature of the right to fair labour practices. The first, to make the point that it's given content by the Labour Relations Act, but it's not fully defined by the Labour Relations Act. That Pretorius, that seems to be accepted that you can have a claim of unfair labour practices that would lead to an unconstitutionality of a statute or the development of the common law that isn't one that's listed in the LRA. The second is that what does fair labour practice mean? It means striking a fair balance between employer and employee in their relationship. And that's from Nahawu. Again, that doesn't seem to be disputed. The third is, as an example, we refer to the case of Pretorius, where the employer had made a promise to pay certain pension benefits and then allegedly reneged on that promise. And the question is, could this be an unfair labour practice? So it's decided at an exception stage, so no firm decision is made, but the Constitutional Court doesn't say, well, this is about financial benefits of employees and employers, it can't possibly be a fair labour practice. It says, yes, no, maybe this could be, go to trial and develop it. And it doesn't rule out the possibility that that could be an unfair labour practice.
At best, in this matter, it's tenuous.
I mean,
there it was a promise for financial benefit,
yes,
which wasn't met.
yes.
Here there's no promise, here it's damages.
Well, but that's the question. So I think this comes to the nub. So as we understand the common law, so this is the position, the common law as we understand it, as applied by the arbitrators, is that if an employee spends an employer's funds for the employer's projects, following correct procedures, but without the authorization of the employer. So there's no authorization of the employer, but it is spent on the employer's projects. That the employer is entitled to recover the full amount of the unauthorized expenditure merely by showing A, expenditure, that B was unauthorized. Doesn't need to show anything else. And that's not limited to intentional or dishonest conduct. It would apply to any breach of the employment contract that led to the unauthorized expenditure. Now, it's true that there is a finding of dishonesty, but that's not the linchpin. The linchpin is the breach of the employment contract, whatever that breach might have been. It doesn't say, well, because this is a dishonest breach, therefore it's different, therefore the rules are different. It says, well, there's a breach, these are the rules.
So this question is going to dovetail very much with the question on arbitrary deprivation, so the inquiry doesn't stop there.
Yes.
No, so the inquiry doesn't stop there at all.
That is the next line, my lordship.
Because then the onus moves.
Yes.
and the employee then gets the opportunity to demonstrate that there was a benefit.
Yes.
In the same way, if the employee sought to claim that the employer should have mitigated, the employer would have had, the employee would have had to mitigate, or
Yes.
defendant mitigates.
Yes.
So your argument with regard to mitigation of damages must apply equally in this scenario.
Yes, no,
So the whole notion of mitigation of damages, notionally, would also be unconstitutional.
well, my lord, so for the purpose of the Fair Labour Practices argument, it's in the specific context of an employer-employee relationship.
Yes.
And what we're talking about here, these principles may apply in other contexts, agent relationships.
So what's
but we're talking about employer-employee.
So what is so different and so special about this relationship?
It's two things, my lord. It's that what the employee has done is still within the scope of the employer's business. So Mr. Roux, and I'll take your lordship briefly to the beer, the wine and the golf clubs, but it's accepted that apart from those small things, what was done was stuff within the business of the university, not what it wanted. I accept that, Lord, it's not what it wanted. But this money wasn't spent to go and build Mr. Roux a new house. It wasn't spent to buy him a new car. It was spent on the rugby club, on bursaries for students at the university. That's what the money was. And everybody, that's not,
That is not what the university says it would have wanted to spend the money on.
right. So the question
It says you've taken that decision about where money must be spent unlawfully, but more than that, you've decided how I must spend my budget and my priorities.
So
So come and tell us what the benefit is. Since you're the one who made that decision, not the council, who considers very carefully how expenditure is made. The council considers a whole number of issues on priority at the beginning of the year. You've simply taken that decision to yourself, at your whim, at your entire whim. You've decided, I'm going to give it on scholarships, beer, wine, and dances. How can that possibly put him in any special position that it's the university that must demonstrate what benefit it is, when it was solely in his decision? His decision, nobody else's. His arbitrary decision. And that's why it doesn't jump out to me as this grave constitutional injustice. It just doesn't. It's not a Carmichael that says, hey, hold on, what's happened here? Here he's taken the decision, 35 million rand. It's a hell of a lot of money over a couple of years.
10 years, I think, yes.
10 years. He decides what the priorities of the university must be. He decides how the budget must be spent. Surely he's got to come and explain what the benefit is to university. Why must the university say, well, why must we have to do this? How does the law, how does it strike to you that there's something wrong about the law? Because you're saying the common law is wrong.
Yes.
What is wrong about the common law when it says, hold on, you make that decision. Remember, we're dealing with the arbitration specific facts, this particular matter. If you're saying we confine it to this matter, without creating great grand principle, how in the context of this matter, 35 million rand, which you've decided what the priorities of the university should be, you've taken away the responsibility of the council. You've taken government money. You've taken money from the state. Contrary to all the regulations in government with regard to how money must be spent, you decided unilaterally, alone, and surreptitiously. In this matter, there's something unconstitutional about you bearing the onus to prove what the burden is. You see how it sounds when you say it.
Well,
It sounds seriously that, Mr. Roux, you've got some explaining to do. And you better first plead what the benefits are, and then come and tell us. Because how's the university to know what was in his mind when he decided on that particular day, when the particular transfer was made, whether he got the request from students, whether he got the request for a dance party? How does the university have to determine what the benefit is on those events. Imagine, what evidence does it lead? It says, well, on this particular day, he spent that amount of money. That's what the KPMG showed. Why he spent it, we don't know. Why he spent it, we don't know. It was his choice. If we spent it, we would have been able to have given you a very, very rational explanation in terms of meetings and procedures and budgets and priorities. He assumed that entire function. How do we prove what the benefit is? Doesn't it sound crazy to you, Mr. Bishop, as it does to me?
You know what, it doesn't sound crazy, but if I...
Please help me, why doesn't it sound crazy? Here's a man who spends 35 million rand on his own.
Lord, I think there's three answers to that.
Yes.
The first answer is, when you're developing the common law, it's not, yes, you consider the facts of this particular case,
yes,
but the law is the law for everybody.
Yes.
The law is the same for Mr. Roo, who was a senior financial officer,
yes,
as it is for all the people below him. Right? And what we're talking about here is, yes, in this case, there was a finding of surreptitious.
Absolutely.
But that's irrelevant to the arbitrator's finding. The arbitrator's finding is not, well, when it's surreptitious, when it's dishonest, then you must prove. It doesn't matter, as long as there's a breach. So that's the law that we're concerned with here. And that's where we say the law is mistaken, or at least the law required a consideration of development, because you've got to look at the other possibilities.
Yes.
Where a mid-level administrator accidentally, let's say negligently expends money out of its employer without, without following the correct procedures, without the proper authorization. The forklift example, the Jaguar example.
I'm not sure a university needs a forklift. I couldn't quite understand that.
Well, I'm not sure.
They're heavy lifting people at the university. They don't need forklifts.
Some of the rugby players are very heavy in the office.
Okay, I don't know.
A new scrum machine, whatever it might be, but it's not Mr. Roo at the top, and it's not dishonesty.
Yes.
So, because those are not relevant to the law.
Yes, but okay. Then
so the law is the same for everybody. It is easy, my lord, to look at Mr. Roo and say, Mr. Roo, you are a senior official. Mr. Roo, you clearly have the resources to employ 2 senior counsel in your arbitration. I have no sympathy for you. But the law is the same for everybody.
Yes, but remember, part of the argument is dealing here with the private arbitration.
Yes.
That applies only to these parties. And the question of development would have to be in the context of that.
But the development, you can't get an ad hoc development to say, the law is this, but in this case it's not. The law, even when the arbitrator is developing the law, has to be developed consistently.
Now tell me, as a general proposition,
yes,
what's wrong with the onus?
Well, it's 2 problems. The first is it creates the likelihood of a double benefit for the employer. Because the employer gets whatever, remember the premise of the argument, my lord, is that this money was spent within the business of the employer. That's the premise. It's not money that was taken from somebody's house or somebody's car. So you get whatever that benefit might be, and you get the repayment of the full amount, unless they can show. So there's a real risk that if the employee cannot show the benefit, the employer gets the windfall from the employee.
No, but these are trial proceedings.
Yes.
This is not, doesn't end at the end of the plaintiff's case.
No, I accept that, but that comes to the second one, is that it's often going to be extremely difficult
for
the employee to demonstrate the benefit.
Good. But tell me, why is it so difficult?
Well, this is in the replying affidavit, page 329 to 330, paragraphs 41 to 43. Particularly 41 and 42 trace.
So this is the replying affidavit?
The replying affidavit, page 329, paragraph 43.
Let's get there. 321.
329.
329. Yes.
So 41 and 42, but then particularly 43. In light of these responses and the fact that the applicant has no access to the university's record, it would be impossible for him to prove compensation benefits. This would be the case with just about any employee. The onus is placed on him or her to show compensation benefit in respect of breach of contract in the form of unauthorized expenditure. Because, again, we can't only think about Mr. Roo. Let's take an example where a official negligently authorizes expenditure on advertising that wasn't authorized by the employer. And R1 million is spent on an advertisement, right? And it turns out that that advertisement had massive benefits for the employer, but the employer is completely unaware of that. But the employer knows about it. The employer knows what benefits they get. The employer is not unaware of what benefits it gets from the expenditure. This is expenditure that it knows about. It knows how all this money was spent.
Which employer?
Any employer, but particularly in this case SU. It knew how the money was spent.
It knew about this expenditure.
It knew the money was spent, yes, because it was all went through the correct procedures.
No,
Just,
no, no, no.
But it didn't know where the money came
no.
from. It didn't know where the money came from, Lord.
Hold on, in fact, it was only discovered by KPMG.
No, what was discovered by KPMG is the source of the funds.
Yes.
But so that it didn't know about. But it knew when the money was being spent over the 10 years that so much was being spent for.
When? How? How did the
Must have
university?
known.
How did the council know that?
No, I don't know if the council would have known that.
No.
But my lord, the point is this.
Who knew it? People down the line who were sitting and having part of the beer tents. They knew. Well, thank you, university, for giving me a free beer and wine. But people up in council didn't know that.
I accept
Because
the
if they did, they would have said, hold on, we didn't authorize this. Then the case would have been very different. But don't make the assumption the university knew or the employer generally knew. Because that's not,
Well,
it's
again,
not been,
my lord,
what has been
I
pleaded.
don't want to get into debate about the facts here because I don't think it's useful.
Yes.
But it does seem to me that if the university has students and it's getting subsidies from the government for the students, it will know about it. It will know. There will be a record of it. It won't be a surprise
council.
to it 10 years later. We had those students. Where
he
did they come
never
from?
disclosed this to the university.
But,
It's
my lord-
part of the finding. The expenditure was never disclosed.
I'm not sure that's part of the finding that the expenditure was never disclosed.
And that's
to
what the
university.
arbitrator says. Well, he says part of the surreptitious. It was,
No.
he knew he was spending unlawfully and never disclosed it.
My lord, as I understand the finding, it was this, that what was surreptitious was moving the funds to these cost centers. And nobody realized that because it was done without
Yes.
the audit trail. So that was done without the audit trail.
Yes.
But when the money is then spent out of those cost centers, and maybe the problem, Lord, is when we talk about the employer, what is the employer? If we're talking about council in the university, does the members of council know? Probably not. They don't know about how things are spent in
Did
the
the
11,000
management
cost
know?
centers.
Did he tell his manager? I don't know.
He didn't tell the manager
Didn't
where,
tell
where the
them.
money came from. No.
Yes, they didn't tell the manager. You know, it's,
But look, for the purpose of the argument about the development of the Commonwealth Act, it doesn't matter.
Yes.
Because it wouldn't matter whether in this case the employer knew or didn't know
well, all
how
I'm
the money
trying to
was
understand,
spent.
Mr. Bishop, is that why is the onus not on the employee, to say, to plead, but you did get a benefit, and this is what the benefit was. Why is that unconstitutional?
Because in these situations, because what it will mean in most cases
Yes.
is that the employee will be unable to do that.
Sorry, let's talk about
Yes.
the inability. What is the inability?
Well, because the employee, my lord, again, there is a disparate power relationship.
Sorry,
And
what is the inability in law?
I don't think it's an inability in law, my lord. I'm not saying it's a legal disability. It's a practical disability.
Sorry, law and practice in terms of court matters. He could have asked further particulars. Could have asked for discovery. Didn't, or he did, but didn't pursue it to its logical end. How can you establish a general principle because the defendants don't exercise all of their procedural rights in a matter? It's the nature of the inquiry. The inquiry is a civil claim for damages. Two parties to it or more parties. Each of the parties have equal access to the rules and all the protections and the procedures. How do you even want this court to accept that an employee, simply because it's an employee, doesn't have access to those remedies in law?
Well, I'm not saying that the employee doesn't have access to the remedies in
Then-
law. What we're talking about here is who should have to go through these procedures, right? Should we, not that it would be legally impossible for an employee to do this. I accept that it might be legally possible for an employee to seek discovery, although I think there will still be situations where the employee wouldn't know what to ask for and the employer would, because the employer would know what the nature of the benefit was.
Excuse me, that's been mind-boggling now. Because it's the employee that makes the decision to spend.
But the employee doesn't always know how
And
that...
sorry,
sorry.
the employee must make the decision to spend which
Yes.
he or she believes is in this broad
Yes.
business of the employee. Otherwise, they'd be stealing money and giving it to friends.
Yes.
Assuming the employee thought
Yes.
he was doing it because it was part of the university's business or part
Yes.
of the employee's business.
Yes.
The employee makes that decision. The employee knows why the expenditure is made at that particular point in time. In fact, would know it better than the people in the university when they decide the budgets.
But no, the question is not why did they make the expenditure. The question is what benefit did that expenditure have for the employer.
But that
And
arises. Sorry, Mr. Bishop, it
But-
arises. He has to establish what the benefit is. So the employee says, well, we don't know. You've made that decision. You know who that student is and what the circumstances of that student was when you gave him or her the scholarship. We don't know. We don't know what the circumstances of the student was. How can you expect us then to prove the benefit to that student when we don't know the circumstances of that student? Can you see how it sounds even more ridiculous?
I don't think it sounds more ridiculous.
Well, you see,
but
who makes the decision to give the student the scholarship?
in this instance,
Yes.
so as I understand it, Mr. Rue with the agreement of somebody else through a cost center. But yes, for the purpose of arguing, Mr. Rue.
It's Mr. Roo.
Yes.
Why does he do so? Because he's got a student that comes to him. Or he goes out to students, depending what his motives was. I don't know. And he considers what the student's circumstances are. He considers whether there's potential in this student in order to give the bursary. He knows that. How does the university know that? He's tracking that student. How does the university know what the benefit is?
My Lord, I
I really can't understand how simply because it's an employee, the employee would be in any disadvantageous position in establishing the benefit. And remember, Jamoka says, you just got to establish there's a benefit. If the actual quantification, the plaintiff has to assist the court with, because they would know the numbers.
My Lord, I
But
think-
establish the benefit, please.
My Lord, I think the point is once you show, and in this case, it seemed that the money was spent not on Mr. Rue's personal, he didn't steal it. That's a clear finding in the arbitration, I think in the arbitration award or the appeal award.
So you want the common
Didn't
law?
steal it.
So you want the common law to be developed now, in circumstances only when it was unauthorized, but in the broad cause and scope of the employer's
Yes.
work, and where it's in the benefit of university. So you have to carve out. You have to carve out specifically for employees this particular benefit of the Constitution.
Yes, well, because it's about fair labor practice, it's about relations between employers and employees. And what the Constitution said is there, what we demand is fairness. We
No, but-
demand fair labor practice.
No, I'm trying to understand what is. Firstly, we haven't persuaded, or at least helped me with this notion of why it's unfair per se, because of the relationship. The relationship's got nothing to do with it. The relationship, the employment relationship, has got nothing to do with it because the employee is not exerting any particular employee power over the employee. The employee is simply spending money unauthorized of the employer. So the relationship issue doesn't come into play
Well,
in a typical
Yes.
unfair labor practice scenario where there is issues of bargaining powers in terms of wages and strikes and all
Yes.
of those things and conditions of employment. These are not typical relationship issues. This is simply A, having spent money unauthorized, or B, why does I not simply carry the burden to prove any benefit to any burden?
I think it's really a question of risk, Lord. So what the risk, if you place the burden on the employee, is that the employer will get whatever the benefits are. We don't know, let's say we don't know what the benefits are, but the employer will get those benefits, whatever they might be, plus full recovery from the employee.
It's not, just to take this to the extreme and to the ridiculous. So a thief goes off and steals 1,000 or 100,000 rand of yours. Okay? But in the process, he goes and buys a car in your name. And it becomes part of your assets. There's no obligation on the thief to have to prove the benefit for you as a general proposition.
My lord, this public case is not about that situation. It says it is different in the employment context because of the nature of the relationship.
But what is this so different? What is so special about this relationship? Because remember, in the context of labor law, the relationship hinges on the exercise of power, which the employer has over the employee. That's the relationship. That's how the law mediates that relationship, by ensuring that there's full and proper protections for an employee. What protection does an employee who uses money unlawfully, unauthorized, what protection must the Constitution give to that litigant, to that employee, that would be special and different to the thief or the fraudster?
Look, because
Why?
What's different about it is that the relationship here is, yes, it's unauthorized expenditure, but it's still spent by an employee for the business of the employer. That's always the case. That's the premise of the argument. So
Hold on. So even if, say, the fraudster and the thief goes and uses the proceeds in the business, for the business of the
But
of
they
the person
didn't
who
have that
needs to-
but they didn't have that pre-existing
the relationship is irrelevant.
And so, but it means that they don't have any of the protections of Section 23(1), because they don't have an employment relationship. They're not
Yes.
employers and employees. So
But why
they
should
can't
they-
rely on Section 23(1).
But it's a matter of law.
Yes.
What is the protection that the relationship gives you here?
Well,
Simply because you're an employee.
it demands
you-
fairness.
Pardon?
It demands fairness. And our submission is that this...
Sorry,
this
what?
is-
Fairness.
Yes, fair labor practices.
Yes, but
Yes.
what's so unfair about it?
My lord, I think I've made my submissions. I don't have any new submissions. Maybe it might... if I can summarize them, I don't have any new submissions to make. I've made the submissions I can
Okay.
on this point.
I'm just trying to understand it because this is crucial for your argument.
No, I accept that, Lord, but
You
if
know,
I can
it's
just
simply just
summarize what I
simply
think
just
is
saying
unfair.
unfair labor practice,
No, I accept that.
which is premised on an employee and employee relationship, and I'm trying to understand what in that relationship, in the context of these circumstances, unauthorized expenditure, even in for the business of the
Yes.
employee, should give the employee this special protection. Because if the common law is that the ownership's to the defendant, why should employees be cut out of the general common law protection because of the relationship?
Chair, if I may take a minute.
Certainly.
Lord, I think what's also different here is that this employer and employee are in an ongoing relationship. So it's different from the thief who steals your money and walks away. This employer and employee, they're in an ongoing relationship.
Wait,
And
this matter.
No, in general. So just because you've spent the money in an unauthorized manner doesn't necessarily mean that's the end of your employment relationship.
Yes, but but so what?
And-
Simply because you have an ongoing relationship, it gives you something different. You
But
can
no,
still
no,
face
no, no.
hold on, you can still face disciplinary proceedings,
Yes,
and you
you
can
can.
be suspended for a couple of months and lose your income.
Yes, absolutely. and you're going to have to pay back the full amount to the employer
Yes.
unless you can prove the benefits, which often will be extremely difficult for you to do.
So the
And-
point being the ongoing relationship. How does that, in any way, then give these special protections
Yes.
that you're seeking to give a defendant employee?
Well, if I can summarize a little. So one, it's a question of risk and where's the risk going to be. And we submit it's unfair here to place the risk on the employee. Second, it's the difficulty.
Sorry, just tell me about the risk.
So it's a question of if it's, and I accept that in this case and in other cases it may be difficult to prove benefit. right? On whomever the onus lies to prove benefit. But it was the employer that got the benefit. It wasn't the employee that got the benefit. And so if the employer is going to say to the employee, you must repay me the full amount of the unauthorized expenditure, unless you can show the benefit. And it may be very difficult to show the benefit for whomever must do it. The employer is going to have a double benefit. It's going to get the...
Jamoca doesn't say that, does it?
That's why we're talking about the Constitution.
No, but Jamoca, that's the common law. The common law says you don't simply just get your double benefit. You haven't proved your damages.
But the defendant would have to show the benefit, and then it would have to be quantified.
Yeah, all the defendant has to show his benefit. If it can't be quantified, plaintiff doesn't get the damages.
Well,
so what is the special protection you seek to give to employees? Because it must be rational.
No, it must be rational.
And it simply can't, wanting to give a particular type of group any special protections under the Constitution when it's not warranted. Is that the common law is then inherently unfair towards them. And yet, how is this onus unfair towards defendants generally who are employees?
Well, look, again, I don't want to repeat myself, but there is often going to be a power imbalance when these disputes need to be resolved. I accept it wasn't the case here, but often the employer is going to have far more resources than an ordinary employee to resolve this dispute. And that's why certain protections are put in place in labour law to try and even the scales. But
but the scales are evened out in court. I'm sorry. This is not an employee. You're not giving the employee simply a right on its own simply to deduct 200,000 rand every month. The employer has to come to court and to get an award of damages. That's the nature of the inquiry.
Yes.
And once the employee and the employee are locked in a legal process, where do the protections lie? And the protections, the law provides the protections to both parties.
The law provides them, but their ability to take advantage of those protections is likely to be very different in an employment relationship.
No.
That's as far as I can
Sorry, hold on. I need to understand this.
Yes.
Because every day, employers and employees go to court, whether it's they go to CCMAs, or they go to labour courts, and then they go to labour appeal courts.
Yes. Well, they go to the CCMA is created precisely to try and equalise some of these power imbalances.
Yes.
That's why the CCMA exists.
But that's in the context.
This dispute wouldn't go to the CCMA.
It doesn't go. It comes to a court.
Yes. And then you don't have those same processes to try and equalise the power balances.
But the power balance is equalised in the court. You've got access to all of the remedies and all of the protections.
If you can't afford the same little protections that the employer can, then you can't take advantage of those protections. And that's why when we're talking about where's the risk lying.
I'm sorry, this is a whole new argument. I'm trying to understand that because employees can't afford lawyers or can't afford to go to court. This is most unusual. They now get a special protection because they can't afford lawyers.
Because
they can't. No. Remember, this is a damages. These are civil claims.
Yes.
Civil claims are determined in a court of law or by arbitration, depending what their choice is.
Yes.
So they come to court, and the court then has to deal with the determination of damages. And the employer says, "This is the damages I've suffered." And to the extent there's a benefit, the onus is on the employee to plead and to prove if there's a benefit. Because that will be part of the cross-examination of the employee. What's the benefit? Well, reputation. Subsidies, I can't say how subsidies can be a benefit, is after my discussion. But maybe you got more TV time, or I don't know. What else would Stellenbosch University get as a benefit? I don't know. He then says that, and the employer says, well, that is so. Then the court says, right, quantify that. He says, I can't quantify this because I've got my expert puts up the best. They have to assist. They have to help quantify. Jamoca says, quantify. Otherwise, you've not proved your damages. So what is what per se gives an employee, because that's the ground in which you're basing
Yes.
this constitutional development, an employee to be in any different position in any other defendant who would have the same protections?
Lord, I do want to move on because I still have one or two points.
Certainly.
I think I've made the submissions, my Lord. I can't take the matter any further.
I'm sorry, I'm just having this debate
No, I
because I'm
understand.
really trying to
I understand,
understand.
but I also don't want to spend the whole day repeating
Oh, no, no.
myself. I've made the best submissions I can on the point, my Lord. My Lord, that brings us to the question of the arbitrary deprivation of the property, which is the second ground. And I don't intend to belabor this because really the fundamental arguments about whether it's fairness or arbitrariness are the same. We've set out the relevant case law, but the substantive merits of that debate are the same as the one I've been having with my Lord. Fairness or arbitrariness are the same debates, and I don't need to retread that ground, my Lord.
Except the case law that you've given the court all deals with where there's, some of it where there's a statutory injunction on the court to make certain awards without the other side. So the National Credit Act
Yes.
cases there was an injunction on the court.
Yes.
And there it was found to be unconstitutional.
Yes, no, but so the argument is here that on whether there's deprivation of property.
Yeah.
And I think Jordan said that there are certain situations where the imposition of liability can constitute a deprivation of property,
Yes.
where there's no connection between the liability and the responsibility for the liability. And then it's really a question of arbitrariness. I think Jordan sort of mixes the line between is it a deprivation and is it arbitrary. And then the reasons we said arbitrary are the reasons I've advanced, and I don't want to repeat
Just
those.
tell me what that reason is, because I don't quite follow it.
Well, again, it's a question of that the real risk that the employee is going to be liable for damages that the employer has not in fact suffered. But it goes back to the debate that we had about where the onus lies and whether there's sufficient protections in Jaboko and procedures in court or arbitration for discovering necessary evidence are sufficient to accommodate that risk, and whether that renders it non-arbitrary. But that's a submission, my Lord. Well, that just leaves me with the question of what this court should do. And we've submitted if it finds that there was a gross irregularity because the obligation to develop the common law existed and it wasn't done, we've submitted two options. Either the court can develop the common.
And whilst they please help me with this notion of plausible finding.
Oh, my Lord, I think I developed that in argument when I was dealing with the question of Carmichael and Everfresh. So it seems to me from a reading of those judgments together that it's where you have a case with either like Carmichael, like you put it, where there's a gross violation, so that'd be the one, or where by necessary implication the development was required given the nature of the case that was pleaded. But it would be, I accept it would be those cases. It's a case,
Sorry, the test you're asking the court to apply today is plausibility.
Lord, I think that is what's said in the head of arguments. It's whether there's
So
a
I'm going to have to
plausible
make a
case.
determination as to.
But I think really that the test is probably higher than that, and I think
Well,
it's on a.
That's not what you've told the court, and I have to grapple with something else about. Because plausible means it simply appears.
Yes.
No more than appears. In every case, there'll be a plausibility of a constitutional issue. People complain they're not being treated equally. People complain they're not being treated fairly. So in every single case, on simple plausibility, it appears to a person who has pleaded their case badly, who's got bad lawyers, bad advice, plaintiffs and defendants, that there's a plausible issue, constitutional issue. It can't be that low, Mr. Bishop. It really can't be. You've told the court that's a test. It's plausible. And because it's plausible, send it back to the arbitrators. The arbitrators will say, the court has sent us this on a whim of plausibility.
My Lord, I think the test is, as I argued to Your Lordship earlier when I was dealing with Everfresh and Carmichael. I don't think there's a single test to be put. I don't think that the court would have said that test clearly. But it's a question of, is this the type of case in which a court would have been obliged to develop the common law, consider the development of the common law? And the same test applies to the arbitrator. And I think it is a case-by-case test. I think your Lordship is probably right that plausibility is too low a standard. But that there is a category of cases in which that obligation exists. And if the case falls in that category and the arbitrator doesn't do it, that then it is a gross irregularity. That's the argument. And then if that gross irregularity exists, this court can either remit it to an arbitrator or a new arbitrator or develop the common law itself. It seems to me that the best relief would be to remit it to the arbitrator for reconsideration. Those are my submissions.
Thank you. It's 5:10 to 1. Mr. Berger, do you want to start, or
I'd like to have a convenience break now.
you have convenience break? Okay, good. Should we come back at about 10 to 2 then? Should we take an hour to get this moving? 10 to 2, if that's suitable. Thank you.